Go live in 5, 4, 3, 2, 1. We are now live.
Wonderful. So I call this meeting to order at 7:01 p.m. This meeting will be conducted in accordance of the State of California Executive Order N2920, dated March 17, 2020. All members of the Rental Housing Committee are participating in this meeting by video conference with no physical meeting location. Members of the public wishing to observe the meeting live may do so at mountainview.legistar.com, on YouTube at mountainview.gov/YouTube, and on Comcast Channel 26. As noted on the meeting agenda, members of the public may provide oral public comments during the public comment period for an item by signing up at mountainview.gov/RHC_speakers or by phone by dialing 669-900-9128 and entering webinar ID 937-7306-8363. Any emails received by 5 p.m. today were forwarded to the Rental Housing Committee. Emails received after 5 p.m. will not be read during the meeting, but will be entered into the record for the meeting. Now I will proceed with roll call. I will start with Committee Member Pardo Dizella.
Present.
Next we have Committee Member Haynes Livesay.
Present.
Committee Member Grunwald.
Here.
Vice Chair Allman.
Howdy, sorry.
And I am here. So we now did roll call. We will now go to the approval of the minutes for January 25, 2021 RHC meeting. Would any of members of the public on the line like to provide comment on this item? If so, please click the raised hand button in Zoom or press *9 on your phone. The speech timer will be displayed on the screen. Oh, that's new. Great. I see no hands. Just double checking. Yes, no hands. So we're going to bring it back to the committee. A motion to approve should include reading the following items. Approve the minutes for January 25th, 2021 RHC meeting. Do we have any questions or a motion?
I'll motion to approve the minutes from January 25th, 2021 meeting.
We have a motion from Committee Member Haynes Livesay. Do we have a second?
I'll second it.
We have a second from Vice Chair Allman. We are ready to go to a vote. Staff, can you please call the roll call vote?
All right, we will begin with Committee Member Pardo Dizella.
Yes.
Committee Member Haynes Livesay.
Aye.
Committee Member Grunwald.
Aye.
Vice Chair Almond.
Aye.
And Chair Ramos.
Yes.
All right, motion passes 5 votes to 0.
All right, now we are going past consent calendar to oral communications. This portion of the meeting is reserved for persons wishing to address the committee on any matter not on the agenda. Speakers are allowed to speak on any topic for up to 3 minutes during this section. State law prohibits the committee from acting on non-agenda items. Would any member of the public on the line like to provide public comment on non-agenda items? If so, please click the raised hand button in Zoom or press *9 on your phone. The speech timer will be displayed on screen. Looks like we have 2 hands up. We'll start with B. Hansen.
Give me just 1 second to get our timer up. There we go.
Sorry, I didn't know I was unmuted. I don't really need 3 minutes. We have been talking about a possible joint session between City Council and RHC. And I would like to urge you to consider doing that. And we will be asking City Council the same thing tomorrow. Basically, we are the Mobile Home Alliance, as you know, and we are not going to go away. We still want to be covered by CSFRA. Our landlord is trying to, some landlords are trying to convince residents that, oh, well, the failure of the lawsuit means that mobile homes can't be covered by rent control. Well, we know that's not the case. We know what that suit was about, and that you actually have the discretion to make a different decision. And so we are going to pursue that in a very friendly and nice way. So that is really all I have to tell you today, and I'm looking forward to hearing some really interesting cases that you have on the agenda. Thank you. Yield my time.
Thank you, B. Next up, we have Alex Brown.
Hey, I would like to fully endorse and echo the sentiments of my friend B. Hansen. I also try to be very friendly and nice. And, given that the appeal for the lawsuit for the writ of mandate to try to get coverage under the CSFRA has been resolved, and that was the thing that several members of this body used as justification for not proceeding in discussion of the coverage of mobile homes and mobile home spaces. I look forward to this becoming an agenda item that I can comment on at a future meeting. Ideally, yes, a joint session between this body and the broader Mountain View City Council, given that every single one of those members has also expressed a desire to see protection for the vulnerable residents of Mountain View's mobile home communities. So I anxiously await action on the part of you august folks. Thank you very much. I also yield the balance of my time.
Thank you, Alexander Brown. Would anyone else like to speak during public comment? I'm seeing no other hands raised. So I will bring it back to the next agenda item, which is 6, appeal hearing, appeal decision regarding petitions. Those are long numbers. 2021-002, 2021-003, 2021-005, 2021-006, 2021-008, and 2021-009. Okay, and now for the appeal script. So this hearing is being held pursuant to 1711J of the CSFRA and Chapter 5, Section H of the regulations adopted by the RHC. In accordance with 1711 of the CSFRA, any party to a petition who disagrees with the hearing officer's decision may appeal to the full RHC for review. In this case, the affected party, the landlord, submitted an appeal. Because the landlord filed the appeal, the landlord is referred to as the Appellant Landlord and will present first. The hearing will be conducted in accordance with the procedures set forth in Chapter 5 of the regulations. The RHC will first take comments from any member of the public who is not a party to the petition who wishes to speak on the matter. Comments are limited to 3 minutes. Staff will provide a report to the RHC regarding to the appeal and tentative appeal decision. The petitioner will be given 10 minutes uninterrupted to make a presentation and arguments. After the appellant landlord has completed their presentation, the respondent tenant will be given 10 minutes uninterrupted to make a presentation and arguments. If there is more than one respondent tenant that wishes to address the RHC, the respondent tenants collectively must determine how to allocate their 10 minutes among themselves. Upon conclusion of both presentations, each party will be given up to 5 minutes for rebuttal, with the appellant landlord presenting the rebuttal first. Upon conclusions of the party's rebuttal, the RHC members will be given a chance to ask questions of staff first, then of the appellant landlord and the respondent tenant. The RHC will deliberate and make its decision. During deliberations, it is likely that the RHC members will have additional questions for staff, additional questions for appellant landlord, and the respondent tenants will generally not be allowed. RHC members are required to disclose any communications that they've had with any of the parties to the petition or the parties' representatives and substance of those communications since the date that the petition was filed. The decision of the RHC is to be based on the record presented to the hearing officer. Information disclosed to an RHC member that is not part of the record is not to be considered in the hearing. Do any RHC members have ex parte communications that need to be disclosed? I'm looking at all of you. Nod, shake your head. All right. Okay. Seeing none, I'm going to continue on. We will now proceed with the hearing. Are there members of the public who are not parties to the petition who would like to speak? If so, please click the raised hand button in Zoom or press *9 on your phone. The speech timer will be displayed on the screen. You will each be given 3 minutes. If there are more than 15 speakers, we will reduce the time allowed for each speaker to 2 minutes in accordance with our rules in Chapter 3 of our regulations. Let's take a look. I am seeing no hands raised. Moving on. All right, staff may present regarding the appeal and tentative appeal decision.
Yes, good evening. Karen Tiedemann. So we're going to go through the RHC decision process, talk a little bit about your role, the scope of the decision, and the process. We want to go over the schedule for this appeal hearing, and then we'll go over a summary of the petition. So next slide. So the RHC's role in this appeal hearing is not to look at new evidence, but really to look at the record and make a decision on whether the hearing officer's decision is supported by substantial evidence. So we're not relitigating the issues. The record is what was submitted at the hearing. That's what the basis is for any RHC decision. And it also doesn't mean that you have to come to the same conclusions as the hearing officer. The real question is, was it reasonable for the hearing officer to come to that decision based on the evidence in the record? You do have the option in your regulations to conduct a de novo review, which essentially would mean a new hearing where evidence is presented to you. We don't recommend it in this instance. It would require us to continue this hearing. It would be a complicated process. And as you saw, if you went through the evidence, there is quite a bit of evidence in this record already. And it was a fairly lengthy hearing, over 4 hours of hearing time in the case. So next slide, this is why we are not favoring de novo review. We think that there's been an adequate opportunity for all the parties to present their evidence, and there isn't a need for new evidence in this record. So your scope of decision, so the petitions in this instance that were submitted, because this is 6 consolidated petitions, define the scope of the hearing. So those petitions set out certain requests for downward adjustments. The appeal is limited to the items that were appealed. So there were a variety of issues that were discussed in the hearing officer's decision, but not everything in the hearing officer's decision was raised on appeal. So those items that weren't specifically addressed in the appeal, which was presented by the landlord, are not discussed in the RHC's decision. So here's just a visual of how this process works. And as we've discussed in the past, there are opportunities for the RHC to hear the same petition multiple times. As you'll see, so the petition comes forward, the hearing officer makes a decision, that decision is appealed to you, the RHC. You have the option to affirm, modify, or reverse the decision, or you also have the option to remand the decision back to the hearing officer. If the decision or any part of it is remanded to the hearing officer, then it goes back to the hearing officer for a new decision. That decision is appealable as well. So that's how it can come back to you. It is only after all of the appeal matters are disposed of, finally, that we have a final decision. And then ultimately, if a party is unhappy, they can bring a court challenge. But until the remand process is fully concluded, there's no final decision in the case. So as the chair went over, you have set a schedule for your appeal hearings. The appellant will present first and then the respondent. There will be rebuttal, and then there will be time for questions and then an opportunity for you to deliberate and make a decision. So this decision, these petitions, so there were 6 petitions, requested downward adjustments of rent. They were primarily related to 2 major issues. All of them were related to a reduction in housing services. They've been grouped in the decision into sort of 2 categories, or in my mind. There were housing services that were reduced that are COVID-19 related. And then there were housing services that there was a claimed reduction that were unrelated to COVID-19. These had to do with responsiveness to maintenance requests, valet trash service, and use of certain grassy areas on the property. So the original petitions were accepted by the RHC on October 12th. They were consolidated on October 29th. The hearing officer conducted a pre-hearing telephonic conference as required by your regulations on November 6th, and then issued a written order and summary that was very extensive as to the type of evidence that he was looking for on November 9th. On November 17th, a supplemental pre-hearing summary and order was issued suggesting a process for the hearing. The hearing was opened on November 20th. On November 20th, the hearing went for over 2.5 hours and then was continued to December 1st, where there was another 2 hours of testimony. At the end of the December 1st hearing, there was no request to keep the record open, and so the record was closed at that point. The hearing officer completed the decision on December 31st, and the landlord appealed it on January 11th. So in terms of the issues in the case, the petitioners requested a rent reduction based on loss of access to the pool. All 6 petitions dealt with that issue. Essentially, the hearing decision determined that there was a reduction in housing services. The hearing officer determined that there was no reduction in housing services from March through June 4th, during which time the appellant landlord had no opportunity to reopen the pool amenities. But starting after June 4th, the public health orders were revised. There was an opportunity to reopen the pool amenities, and the hearing officer made a finding that the pool amenities could have provided greater service in compliance with the public health orders based on the evidence. So the tentative decision recommends affirming that portion of the hearing officer's decision. The second issue that was subject to the petition was loss of access to the fitness center and hot tub. Once again, all of the units requested a rent reduction for this. These are also COVID related. And the issue that was raised was that the fitness center could have been reopened sometime in July, but was not. And so the hearing officer granted a rent reduction for all units from July through September 30th. In reviewing the record and in the landlord's appeal, the landlord cited to certain evidence that was not in the record, but was compelling that they could not actually have reopened the fitness center. The landlord also cited to the fact that the petitioners did not raise the lack of access to the hot tub in their petitions. So based on the fact that it's not clear from the decision how much of the rent reduction was based on the lack of access to the hot tubs, and the fact that despite the fact that the landlord didn't submit the evidence at the hearing, there did appear to be some evidence that they couldn't reopen the fitness center when suggested in the decision. The recommendation is to remand this portion of the decision back to the hearing officer to determine whether they could have reopened the fitness center, and if the fitness center could have been reopened, how much of the rent reduction was attributable to the hot tub, which was not specifically requested by the tenants. The third item in the decision relates to lack of, I apologize for the cat, lack of access to lawn and surrounding areas. This decision, this part of the decision, I will admit, is a little confusing. The petitioners raised the issue of being denied the ability to work out and conduct fitness groups in common areas of the property. And that the landlord was denying them access to that. They were proposing that as an alternative to the fitness center. When they did try to use parts of the common area, the landlord gave them a cease and desist notice and then refused to continue to discuss with them. So based on the fact that they were not allowed to use certain areas of the property that could have been used in conformance with the public health orders, the hearing officer granted a rent reduction, and the tentative decision is that based on the evidence in the record, that that portion of the decision be affirmed. The fourth item has to do with valet trash service, and this only relates to a single unit, that is unit 414. Unit 414 raised the issue that the tenants are all required to pay $25 a month for valet trash service, but the tenant submitted evidence that the valet trash service is deficient, the trash is not picked up, and so the hearing officer granted a rent reduction on this basis. The rent reduction was to remain in effect until either the $25 a month fee was removed from the tenant's required payments, or the tenant determined that the trash service was satisfactory. And the appellant landlord raised concern that this leaves it to be very subjective and in the petitioner's sole subjective judgment as to when this rent reduction terminated. And based on that fact, the tentative decision is recommending that this be remanded to the hearing officer for the sole purpose of determining a measurement for when the valet trash service is adequate, and therefore the $25 fee would resume. Item 5 deals with lack of management response to maintenance requests. All of the units raised this issue. There were a variety of issues raised by the petitioners regarding maintenance requests, issues related to lack of hot water, problems with plumbing, problems with exhaust fans, carpet cleaning, etc. The decision goes into great length of discussing all of the specific maintenance issues and the durations during which the landlord took to respond to those issues, and generally finds that the landlord's response time was reasonable given the severity of some of the issues, the need to bring in other professionals, etc. But the decision then concludes that there was a pattern and practice of failing to respond to maintenance requests, and that the tenants, one of the housing services that the tenants were entitled to was a responsiveness to maintenance requests. And so a rent reduction was awarded to all of the units, with the determination that the lack of responsiveness had been in place for at least a year. In reviewing the record and the decision itself seems to contradict the ultimate decision, and the record also contradicts it somewhat. The tentative decision is recommending a reversal on this issue because there isn't a link between the evidence that was presented and the hearing officer's ultimate decision. And then the final issue in the decision relates to Unit 2103. This has to do with the residents of Unit 2103 being involved in a confrontation with the appellant landlord's employees that left them feeling that they could not use some of the grassy recreation areas that tenants are allowed to reserve for private use. And so a rent reduction was awarded to the tenants in this instance on the basis that the tenants could not use the grassy area or did not use it because they felt uncomfortable. The appellant landlord raised issues regarding the fact that there was no evidence in the record that the tenants actually would have used the grassy recreation area, that they would have used it regularly on a monthly basis, etc. And there is no evidence in that record on that effect. And on that basis, the tentative is recommending a reversal of the decision on that aspect. In accordance with your procedures, once the tentative is issued, the parties are entitled to submit supplemental responses. And in this instance, we did get supplemental responses from both the petitioners and the landlord. The tenant response to the tentative appeal decision included 3 major issues. One was that the contention that the hot tubs should have been appropriately included, that they were raised, and they were raised as part of the pool amenity. The problem with that is the hot tubs, in the hearing officer's decision, the hot tubs were linked with the fitness center, not with the pool amenity. And so in the pool amenity, there was an award of a downward reduction. There was no indication in the record that there was an additional need for a downward reduction related to the hot tubs. The tenant response also raises issues regarding that the landlord had the opportunity to submit additional information on the fitness center and whether they could have reopened. And that is accurate. The landlord was given multiple opportunities, and the landlord did submit a newspaper article as part of the appeal, which is not appropriately in evidence. The tentative does recommend this be remanded, so that can be considered. So that's an issue that you may want to discuss. And then finally, the tenant response raises issues regarding Civil Code 1942.9, which is discussed in the tentative. 1942.9 was adopted January 29th. It is part of the eviction relief bill that was passed by the California legislature. It does include language that would prohibit tenants for petitioning for downward adjustment for housing services that are reduced or withdrawn in compliance with the public health orders. You will note in the decision there is a discussion about the retroactivity of that. The tenants also raise another issue regarding the application of 1942.9, and that is that 1942.9 would prohibit a rent reduction for the withdrawal of services that are in compliance with the public health order. what the hearing decision finds with regard to particularly the pool amenity and the lawn areas is that the reductions were not in compliance with the public health orders, that actually the landlord could have provided additional services in compliance with the public health orders. And so the tenants have raised a valid issue on that point, that 1942.9 would not prohibit a downward reduction if there was a finding that the withdrawal of services was not necessary to comply with the public health orders. The landlord also submitted a response to the tentative appeal decision. The landlord also addressed issues related to the application of Civil Code 1942.9, raising additional issues about retroactivity and what the appropriate standard for retroactivity is. The appellant landlord argues that 1942.9 should be applied retroactivity on the basis of certain case law related to the repeal of statutes. 1942.9 is not a repeal of a statute, but rather it is a preemption of local regulation. And so the cases cited do not address the retroactivity issue. The appellant landlord also does not address the issue about whether they were in compliance with the orders or exceeded withdrawing the services. The appellant landlord also raises issues about the application of the Golden Gateway decision, which was raised by the appellant landlord in their response to the petition and was addressed by the hearing officer and is also addressed in the tentative decision. The appellant landlord disputes the interpretation of that decision. The appellant landlord also states that the pool closures were in accordance with the orders, although doesn't cite to any new evidence, and the evidence in the record would support that additional use of the pool was allowed. And then the appellant landlord raises issues about the lawn area access and the ability of the tenants to use it for fitness activities, and in particular raises the fact that the tenants were initially using parking areas for their fitness activities and that parking areas are not appropriate areas. The decision, however, doesn't rest on the prohibition of use of the fitness areas. The decision from the hearing officer actually rested on the fact that the appellant landlord didn't allow the petitioners to use any other areas of the property for their outdoor activities while the fitness center was unavailable. So those are the various issues that are raised in the appeals and the responses to the appeal and the tentative. And I think at this point in time, the process calls for the landlord as the appellant to make their arguments.
So next up, we have Appellant Landlord. Please click the raised hand button in Zoom and staff will temporarily promote you to a panelist. The speech timer will be displayed on the screen. You will have 10 minutes. All right, we have Servando Sandoval.
No, this should be Ms. Kazasik. I will promote her.
Okay. Ms. Kazasik, are you there?
I am here. I don't know if anyone can hear me.
We can hear you.
Yes.
Okay, so Mr. Sandoval will actually be the one that is presenting our argument. He is also with Paul and McKay, and is on the pleadings as well. So if you could promote him to a speaker, that would be great.
He has also been promoted.
Thank you.
You may begin and the timer will start when you do.
Thank you. Good evening, committee. I wanted to address a couple of issues with respect to the tentative decision and the decision itself. Aside from the clear misapplication of SB 1991, which I'll address in the latter part of my argument, the affirmation of the hearing officer's awards for the swimming pool and the lawn access are simply unsupported. First, want to address the Golden Gateway applicability to this case. The Supreme Court decision in the Golden Gateway Center held that where there is an unavoidable short-term inconvenience which interferes with the provision of housing services, a reduction of rent should not be granted so long as that inconvenience does not impact the ability of the to use the rent premises as a residence. And that is what exactly we're dealing with here. There's another decision issued by another hearing officer in the case of Smith versus Prometheus Park. That's case number 202-10010. And that decision was issued on January 11th of this year. That hearing officer held that Golden Gateway does in fact apply to these types of situations, specifically service reductions that were impacted by COVID. The hearing officer in that case held that there was recognized that there was no rent abatement was justified for the period of time in which the amenities were either unavailable or their availability was limited, such that the impediment on their use did not impact the resident's ability to use the rented premises as a residence. That's exactly the situation here, and therefore we contend that the decision by the hearing officer in this case is not supported and that the decision of Golden Gateway should apply. With respect to the pool access loss, it is interesting to hear the summary of the positions of the tentative decision that was issued here in this case. What landlord is contending is that they in fact did comply with the health orders and that they did everything possible to try to comply with the ever-changing health orders that were issued by the County of Santa Clara. The hearing officer in the tentative decision, in fact, would punish the landlord because in their view, the landlord did not do enough to reopen the pools. Additionally, it is inconsistent or essentially unsupported the amounts that were awarded in this case to each unit for the period of time in question. There was no evidence presented by any of the tenants that support the rental amounts that were awarded to be reduced by the hearing officer. It appears that the hearing officer assumed that the tenants would have unfettered access to the pools during that time period, which is simply not the case. We believe that obviously with the restrictions and the fact that people needed to make reservations, the additional time to sanitize, that the tenants would in fact not have unfettered access, and in fact, the availability of the pool would not warrant the amounts that were awarded without the evidence, and therefore we would ask that that decision be reversed as well. With respect to the lawn access, the evidence presented at the hearing overwhelmingly showed that tenants were in fact not prohibited from using the lawn areas. The entirety of the evidence that was filed and submitted in support of these decisions, in fact, dealt with use of the parking areas for exercise classes. Well, tenants didn't have the right to use parking areas for these uses prior to COVID. So for the hearing officer to award a rent reduction because the landlord was not allowing them to use those areas for exercises during COVID simply is not supported by the CSFRA. Therefore, we would ask that that decision with respect to the lawn areas be reversed. The repeated fundamental flaw with the hearing officer's findings in the tentative decision is that appellant never prohibited any residents from using the lawns. Rather, the landlord simply addressed the violations of the health orders in place at the time and also addressed complaints from other residents regarding the noise and the gatherings that were taking place in the common areas. This is not a service reduction warranting an award. With respect to SB 91, the Civil Code Section 1942.9 went into effect on January 29th of 2021. This section states that notwithstanding any other law, a landlord who temporarily reduces or makes unavailable a service or amenity as the result of compliance with federal, state, or local public health orders or guidelines shall not be considered to have violated the rental or lease agreement, nor to have provided different terms or conditions of tenancy or reduced services for purposes of any law, ordinance, rule, regulation, or initiative adopted by a local government entity that establishes a maximum amount that a landlord may charge to a tenant. The service reduction petition, this portion of the CSFRA, is exactly the type of ordinance or law that SB 91 is intended to apply to. So SB 91, in fact, precludes a tenant from alleging a service reduction under the CSFRA and has the effect of a partial repeal. And in fact, RHC concedes this in the tentative decision. So the only question left is the timing and whether it precludes these petitions. The retroactivity under Myers and Langdorf does not apply. That's the decisions that were quoted in the tentative decision. That is the incorrect standard to the current circumstances. Here we apply the Mann standard, and that's that the repeal of a statutory right or remedy triggers the application of rules distinct from the traditional law regarding the prospective or retroactive application of a statute. The Mann standard further states that when a pending action rests solely on a statutory basis and when no vested rights have been vested under a statute, a repeal of such a statute without a savings clause will terminate the pending actions based thereon. So what is the statutory basis here? The Mountain View Charter Section 1710 allows the tenant to petition for a downward adjustment of rent on the basis of a decrease in housing services. So that's what we have here. So in reality, at this point, there has been no rights that have been vested to these tenants. These decisions here, the decision for these petitions, is still a pending action. It's not a final decision. Therefore, there's no final vested right. Finally, we turn to the legislative mechanism by which the right of action is abolished and effectively repealed. The repeal does not need to be a direct repeal, specifically referring to a statute. Thus, legislative action can affect a partial repeal of an existing statute, and the substance of the legislation determines whether it constitutes a repeal. So when we look at the substance of the legislation, it's not the label to determine whether it operates a repeal. In fact, here, the SB 91, 1942.9, does in fact take away the right for tenants to file these types of claims. So even where the words of a statute are not expressly words of repeal without a savings clause, the effect is the same insofar as the application of the principles is concerned when the legislature, by apt expression, has withdrawn the right and remedy in the particular case, including all pending actions. Again, that's the situation we have here. So SB 91 does not have a savings clause and therefore demonstrates that the legislature did not intend to save the statutory protections previously available to tenants under the CSFRA. Really, as there's no legal authority to determine that SB 91 is not operative in this case. In fact, we contend that it does apply in this case. So on this basis alone, all rent reductions that were awarded to the tenants should be reversed and dismissed with respect to the limitations due to COVID. SB 91 applies to these petitions and to any other petitions that might be filed alleging these types of service reductions. There is no right to seek reduction in rent due to the COVID closures. Specifically, when the hearing officer would hold that landlords have to try to second guess health orders, putting other tenants' health at risk. Thank you for your time.
Thank you, Mr. Sandoval. We will now go to the respondent tenant. Please click the raised hand button in Zoom, and staff will temporarily promote you to a panelist. The speech timer will be displayed on the screen, and you will have 10 minutes. So let's take a look. I don't see anyone raising their hand.
Yeah, I promoted.
Oh, you already
Guy.
got him.
Yep. So he should be able to unmute himself and turn on his video if he wants.
Yes, thank you very much. Can you see me and hear me?
I can, and you can begin at any time. We'll start the timer then.
Great, thanks very much, and good evening. I'm the tenant in Unit 412. I'm speaking on behalf of our own petition, although I understand that a lot of the issues apply to a number of the different petitions. So first of all, I just want to kind of observe that the purpose of this petition process, as I understand it, includes to be kind of accessible and inclusive to tenants who are not kind of professionally represented throughout the process. And I'm making that observation because we're not professionally represented. We're all professionals with our own jobs. We don't have a full-time law firm representing us in these proceedings. And as far as I can tell, we're the only party involved, including other folks such as the hearing officer or the rent committee, who aren't kind of doing this professionally. We're just trying to get relief basically in our spare time, using what we can understand of the process through the website and through the housing committee to get relief for the reductions in services that we've experienced. And that comes up through a few of the issues, I think. When it comes to the question of whether to remand a proceeding or an issue, despite already having approximately 4.5 hours worth of testimony, a lengthy evidentiary, a lengthy period in which the record was open for evidence. This has been extremely burdensome on all of us already. And there's a lot of us, frankly, a lot of professionals who are spending a lot of time on this process. So the second issue where this comes up is kind of construing the precise language in our petitions as to whether when we referred to the pool amenity, we should be kind of, whether that should be kind of narrowly construed to exclude the hot tub. And the third issue where that comes up is really just basically whether we should hold parties to the lengthy evidentiary period that already occurred, that we already had, that was already opened and closed, that already had extensive discussion, hours and hours worth of discussion, and weeks worth of opportunity to provide evidence, including between two hearings where there was a lengthy opportunity of multiple weeks to provide follow-up evidence to issues that were raised and discussed in the first hearing, whether to hold the parties to that, especially, frankly, the parties that were professionally represented by counsel. And weighing against that, the burden that a lengthy ongoing process is going to continue to impose on all of the tenants that are seeking relief here. So on to the substantive issues in the appeal. I guess firstly is the hot tub issue. And we did hear from the staff presentation that the hearing officer's decision included linking the hot tub with the fitness center. And we acknowledge that the hearing officer made a decision to group those two amenities together in the decision. I guess our view is that tenants shouldn't be prejudiced because of that kind of organizational decision by the hearing officer in constructing his initial decision. The tenants did raise the hot tub. We referred to it as a pool amenity. I suppose if we were professionally represented by counsel, we would have, set out every single line item, every way that we could describe each amenity that was withdrawn. But we had 4.5 hours worth of meetings where our intent was crystal clear. We discussed the hot tub for 2 hours on December 20th, I believe it was, and for another 2.5 hours, on November 20th, and another 2.5 hours on December 1st. So there was ample opportunity, and there was an open record between those meetings for the landlord to submit whatever evidence and arguments it chose to do so with regard to the hot tub. And in fact, it did. No one was misled by the wording in our petitions. Everyone understood us to be referring to the hot tubs, including the hearing officer. And the landlord likewise produced evidence and responded to those arguments in both hearings. So to hear now, after both of those meetings are over, after the record is closed, after the decision is issued, that our wording wasn't precise in the petition, it just feels like kind of an abusive process, frankly, to raise that after the entire hearing is over and try to invalidate a piece of the decision that was fully argued. And beyond that, I think if you look at the landlord's emails, which we cited in our responsive arguments for this hearing in response to the tentative opinion, the landlord itself in its communications to the tenants refers to the hot tub and the pool collectively as the pool. The initial email announcing the closure of those amenities doesn't sort of separately mention the hot tub. It just talks about the pool. If you look at the graphics on the landlord's website advertising the pool amenity, it's very clear that it's one amenity. It's architecturally integrated. The hot tub is actually set into the pool. The pool's not a rectangle. The hot tub actually intrudes into the area of the pool. It's all piped by the same piping, and the pool guy maintains them both. They don't have a separate hot tub guy. Like, it's one amenity, and that was what we were referring to. And I would hate for us to be prejudiced just because the landlord, I think, kind of strategically claims not to understand that when we refer to the pool amenity, we're referring to the collective pool amenity, just like the landlord does in its email communications with the tenants. Onto the fitness center, this has been fully agreed for months, fully argued for months. There were plenty of opportunities for the landlord to submit evidence. And in fact, they did attempt to submit evidence regarding whether closing the fitness center was obligatory under the COVID health restrictions. They just didn't do a very good job. And it sounds like after the record is closed, they're now attempting to submit new evidence. And it's just kind of frustrating because, to be honest, there are aspects of the hearing officer's decision that we probably would have appealed if we had understood that any appeal would be kind of limited to the specific issues raised in the landlord's appeal. We lost on the main claim we made, which was that irrespective of the COVID requirements, we should get compensated for all of the amenities that were withdrawn. Certainly the CSFRA doesn't have a force majeure clause or an act of God clause or a legal necessity clause. We lost on that claim. Frankly, I wish that we had been professionally represented and knew that we would have to specifically appeal it, but we didn't. And I think we're okay living with that fact. But it's a really tough pill to swallow that the landlord would get a second bite at the apple here when the tenants don't, even though the landlord is the one that's professionally represented and the tenants aren't. And then finally, and I should also mention, the hearing officer did make a decision to award us a rent reduction for both the fitness center and the hot tub. And I agree that it's kind of regrettable that it's kind of lumped into a single number. But that was the decision, and there's really, like, the fact that we can't specify exactly how many dollars relate to the hot tub isn't a reason to reverse the hot tub piece entirely. And then finally, under SB 91, there was some, I think basically we tried and lost for the argument that SB 91 would have prevented. We argued and attempted to get compensated for the withdrawal of all the amenities, including those that were required by COVID-19 to be withdrawn. And we don't view that as a punishment. We just view that as allocating the loss associated with the restriction of amenities that were required by law. I mean, either the landlord has to bear that loss or the tenants have to bear that loss. And our view is that CSFRA clearly apportions that loss to the landlord, not punitively, but just as a matter of cost allocation. We lost on that issue, and that's the issue that SB 91 would have prevented. The only thing we won on were the proportion of the landlord's response that was not in response to the COVID, that was not in compliance with federal, state, or local public health orders or guidelines. We didn't win a single cent for withdrawals of amenities that were required by public health orders. We lost on those cents. The pennies that we won were those that were caused by the landlord's overreach in response to COVID-19 public health orders. It's almost like it's precisely the quantum of their overreach that was the basis of the hearing officer's decision. So even if SB 91 is read to apply retroactively, and just to be clear, we completely agree with the tentative decision that it should not apply retroactively. But even if it were to apply retroactively, substantively, we still think it's very clear that the portion of the withdrawals of amenities that we received relief for are only those that were not required by COVID-19 health requirements. They were not withdrawn as a result of compliance with federal, state, or local public health orders or guidelines. You know, you could imagine a landlord going way overboard, even further overboard, and just changing everyone's locks in the entire apartment community, and then arguing that they were doing that because of COVID. It was an overreach. They did it because of COVID, and obviously that kind of overreach is not something that SB 91 should defend. It really only defends actions that were required by, that were taken as a result of compliance, not as a result of overreach. So we'll reserve the rest of our time. Thank you.
Thank you, Mr. Walker. We will now go to the appellant landlord. You have 5 minutes to rebut any statements made by the respondent tenant. Please limit your comments to the rebuttal rather than repeating information already presented.
Thank you once again. First, let me address the issue of the health center. And in fact, there was evidence that was submitted. It wasn't that it was not submitted. It was just overlooked by the hearing officer. The various health orders with respect to what amenities could be reopened at various times and the subsequent orders that were issued by the health department were in fact submitted to the hearing officer. And that specifically said that the health fitness centers could not be reopened until October 5th. And that is the basis for the appeal. Not that we somehow missed the opportunity to submit evidence. With respect to the hot tub and the pool, again, we contend that the amounts that were awarded for those amenities there was no evidence supporting those amounts. The pool was awarded $175 per month. The fitness and the hot tub was awarded $125 per month reduction. That's a $300 reduction for those two amenities. There's absolutely no evidence submitted to support the value that was apportioned by the hearing officer as to those two items. The tenants talk about a double standard. There's no double standard. The landlord has the right to appeal the decision. They have the right to seek a redress when they feel that the hearing officer made a mistake, which we contend that that's what happened here. It would simply be an abuse of discretion not to remand those items that need to be further looked upon by the hearing officer to make sure that the decision is correct. We have to be clear here that the pool was not completely closed down. While the pool was closed down initially, that was the health orders that were issued by the health department. Subsequently, the health department issued separate orders advising as to what parameters could be followed or have to be followed by landlords before they can reopen their pools. And that's exactly what the landlord was trying to do here. The landlord was trying to do the best it could to comply with the orders and also to make sure that they were not putting the tenants at risk of getting infected with COVID. But here, the hearing officer found somehow that he felt that the landlord did not do enough. We're not talking about a landlord who overreached and simply closed down all of the amenities or changed all the locks, as the tenant indicated. They're doing their best to try to comply with health orders and to keep their tenants healthy. And instead, what they get here is a tenant petition to reduce their rent because they're trying to comply with the health orders. This is essentially Monday morning quarterbacking by the hearing officer, trying to decide what the landlord could have done. Should they have done more? Again, the landlord was simply trying to comply with the health orders and trying to keep their tenants healthy. Upholding the decision by the hearing officer places the landlords everywhere in the unfortunate position of second-guessing health orders. And we've seen that all too often by individuals who want to either ignore the health orders and creating the possible harm to other people. That's not what the landlord was trying to do. They were simply trying to do what they could to keep the amenities open and to keep the tenants healthy. And that is the premise of SB 91. We want to make sure that landlords are doing what they can to keep tenants healthy, while at the same time trying to comply with the ever-changing health orders. Business owners understand that, the difficulties of trying to comply with the different closure orders imposed by the county. And then we should be doing that, but they should not be penalized when somebody feels they didn't do enough. Thank you.
Thank you, Mr. Sandoval. We will now go to the respondent tenant. You have 5 minutes to rebut any statements made by the appellant landlord. Please limit your comments to rebuttal rather than repeating information already presented.
Okay, yeah, thank you very much. I guess I'll respond to the 3 arguments that Mr. Sandoval raised. First of all, the fitness center. I think the tentative opinion is pretty clear, and the staff report is pretty clear that the fulcrum of the remand there is based on new evidence that was not submitted in the record. So I'm not sure what else to say to it other than that we agree with the staff. There was an evidentiary period. It was fully submitted, fully argued. The hearing officer didn't agree with them, but that's not a basis for a remand back to the hearing officer. Especially in light of the burden that imposes on the tenants. Second, Mr. Sandoval claims that there was no evidence to support the value of the pool withdrawal indicated by the hearing officer. And the thread of truth in that is that you will never find an objective market-based analysis for the value difference between a pool that's fully opened and a pool that's open only from the hours of 11:30 to 5 p.m. and only to 1 household instead of 5 households. That granularity of evidence just isn't available. The tenants did submit evidence as to the valuation of the pool amenity, and the hearing officer's decision reflects that evidence was incorporated into the numbers presented. Thirdly, also on the pool issue, I think Mr. Sandoval said that the pool was not completely closed down. But actually, one of the 2 swimming pools was completely closed down, completely without justification, completely without any sort of rational relationship to the COVID health orders whatsoever. If one pool is even partially opened, it's perplexing that anyone could think that the second pool would need to be entirely shut down as it was. Furthermore, restricting the hours of the remaining swimming pool to 11:30 a.m. to 5 p.m., restricting it to only 1 swimmer instead of the 5 that was required as a simple matter of arithmetic under the public health orders based on the dimensions of the pool. This is not rocket science. It's not brain surgery. It's just a matter of reading the orders and doing the minimum possible to intrude on your tenants' lives during a time when everyone is stressed out by COVID and under new burdens that we're not used to bearing. So we're not asking, all we're asking at this stage is that the landlord read the orders and not withdraw things beyond that. Or if they choose to overreach, there should be Monday morning quarterbacking to allocate that loss as required by the CSFRA to the landlord. It's exactly what the housing officer or the hearing officer did, and there's no reason that it should be reversed or remanded.
Is that it?
That's all. Thank you.
All right. Thank you, Mr. Walker. Now we will go back to the RHC. RHC members, do you have any questions for staff? Go ahead, committee member Partizella.
So, question for council. How concerned or how aware should we be of the potential for our decision as to the retroactivity issue to have ramifications beyond just this appeal, but as to other appeals or other petitions where similar issues are going to be raised regarding a decrease in services and whether, in fact, that is consistent or not consistent with SB 91?
I'm not sure that we know. There was one other petition filed somewhat similar with a different decision from that hearing officer, and that decision is final. So there can't be any further appeal on that decision. And, you know, the RHC will not be accepting petitions that relate to decrease in services post the enactment of SB 91. So I don't think we can really say if there would be petitions that come in prior to that. And if there were, the hearing officers would have to evaluate that issue.
If there were other tenants in the same complex and they provided some sort of notice previously regarding these same issues, whether it's the pool or the hot tub or what have you, and that notice was by email or orally or by whatever mechanism, would they now, if we you know, come to a decision that essentially affirms a lot of the findings by the hearing officer in support of some kind of reimbursement or reduction for those services, are those other tenants in the same complex going to be in a position then to also just file a similar petition saying, we also complained about the pool or the hot tub, you know, last summer, and we should be entitled to a similar reduction? So, you know, the question is really, is everyone else in the building going to essentially be able to follow in these footsteps, provided that they had given sufficient notice about these various issues?
I think that would be a decision that a hearing officer would have to determine as to whether those petitions are timely.
Committee Member Pardo-Zazella, is that all your questions?
It is for now. Thank you.
Following up on that question, when a petition is served, a tenant petition is served, what kind of notice is given to all the other tenants in that unit? Are they in the dark essentially, or do they have some notice that something's going on?
Notice is not given to other tenants in the property. Petitions are public record. So, you know, tenants in the building could request copies of the petition, but there's no notice to anybody but the parties.
So if you're in a large complex and your neighbor files a petition, you probably wouldn't know until it's actually public record if you do pay attention to those kinds of things.
Right, right. I mean, and you would have to know to ask about it. I mean, it's not like we publicize decisions.
All right. Next question is by Committee Member Grunwald.
Thank you. Karen, I thought I heard the appellant mention that the prior decision from the hearing officer had considered SB 91, perhaps as being retroactive, or sorry, could you clarify there? What, like, that was there a decision regarding the applicability of SB 91 in that hearing officer's decision?
No, I think I think I understand the confusion. So SB 91 didn't come into effect until January 29th. And frankly, I don't think that SB 91 was even any version of it that was remotely like what it finally ended up being was available to the public until a few days before it was enacted. And this decision was issued on December 31st. I think what the appellant landlord is referring to is that there was another hearing officer decision somewhat on similar facts relating to a different case. What the appellant landlord stated was that another hearing officer found that the Golden Gate case did apply. That decision actually doesn't really rest on the Golden Gate case. What it rests on is that in that situation, the landlord did comply with the public health orders and did try to reopen services as much as possible. That was the finding of the hearing officer from my review of the case. did try to reopen services such as the pool as much as possible based on the public health orders and gradually reopen more and more facilities over time. So the facts are different in that case, and the decision really rested on those facts as opposed to any determination of the case law.
Thank you for the clarification. Golden Gate was COVID related. Is that true?
No.
Or was it? No. Okay.
No, Golden Gate was the case. It's an older case related to the repair of balconies on a property in San Francisco, where the balconies were unusable as a result of the need to repair them. And the tenants petitioned for a rent reduction, which was granted by the San Francisco Rent Board. The court rejected the rent reduction on the basis that the repair of the balconies was actually a housing service that was required to be provided, and therefore the temporary inconvenience of not being able to use the balconies was balanced against the need to provide the housing services of a repair to those balconies.
Thank you. Okay. So the reason I'm asking is I'm trying to ascertain to what extent, when we're evaluating how appropriate, whether the hearing officer's decision was appropriate, if it sounds like Golden Gate was a unique case. It's a building, and it's something between. There are facts that are specific to the building and the tenants who are there. I'm wondering is there precedent when it's something that affects all of California similarly, or all of, let's say, Mountain View, where could be the fires, could be COVID, could be earthquake. I don't want to say that, but then all rent boards would have similar. There would be not precedent elsewhere, but could we expect the hearing officer would know the calculations and how to do calculations based off of how other decisions have been made pursuant to specific events that are, to some extent outside the control of the specific tenant or landlord?
Well, so in this instance, the hearing officer did do a pretty thorough job and did review all the case law. There isn't a lot of case law. Frankly, the Golden Gate decision, there were some references to a few other cases, but they're not directly applicable. And what the hearing officer did, and as you, I'm sure, saw, this was quite a lengthy decision. The hearing officer did try to very carefully address the issue that there were some things that were outside of the landlord's control. So, for instance, there were no rent reductions awarded before June 4th on the premise that between March 16th and June 4th, the landlord really couldn't have done anything. They couldn't open the pool, they couldn't open the fitness center. Then starting on June 4th, the orders came out that you could allow access to some amenities. So reductions were awarded. There were orders in July that fitness centers could be reopened. So reductions were awarded in that time frame. And then the hearing officer did not award any reductions after September 30th on the basis that the orders were then again changing, and that those were circumstances that were post-petition, that were not subject to the petition, so changed circumstances. So I think that the hearing officer did really carefully evaluate the circumstances of the COVID orders and did award the rent reductions based on all of the evidence that was presented. And the hearing officer's finding based on that evidence, like for instance with the pool, that there could have been greater access to the pool and continued compliance with the health orders. And that actually pool access was restored to some extent after the June 4th order, but then it was limited even further subsequent to that. Whereas in the decision that I referred to earlier, the other decision that was issued by hearing officer, pool access was restored after the June 4th orders, and then increased based on changes in the orders. So there's a difference in those facts, and that's what the hearing officer really awarded the rent reductions based on. If throughout the entire time, the landlord could not have reopened the pool, based on the hearing officer's decision, my presumption is the hearing officer would not have awarded a rent reduction. But there was a finding that the pool could have been opened and greater access could have been provided to the residents.
Thank you. That's helpful. And I think, sorry, I'll just get to the specific example. The reason I asked is if there had been, let's say, 10 decisions across jurisdictions of similar nature, because a pool is a pretty common, part of the lease that has been removed, I think, across the board. And in those other 10 decisions, the grace period that a landlord would have been given to figure out how to, if I'm not exactly clear if June 4th was the day that the rules were changed, but would we be able to use or ask the hearing officer to look at other jurisdictions and say, okay, it looks like the grace period across them was 30 days, 15 days, 30 days of expectation that the landlord has to figure out how to resolve the issue, how to implement a new system and cleaning protocols and things like that. Without asking for new facts, I think it's more like, are we allowed to remand to ask that other jurisdictions be considered if there have been? I haven't seen any, but I'm kind of assuming that there would be other cases out there that have been decided in a similar manner.
Yeah, no, I understand what you're asking. I mean, decisions in other jurisdictions are not really precedential for our decisions because every jurisdiction's regulatory scheme is different. So you also have to take that into account. I am not aware of other decisions, although I suspect there are. But, the hearing officer really makes their decision based on the evidence in the record. And, the evidence is pretty extensive in this record. There were a lot of health orders submitted. Frankly, I think almost all of them were submitted. I'm sure that there were a few that were not relevant. And the decision was really based on the review of those health orders and what they allowed and how they could be implemented. So I think that's probably the standard that's more appropriate for the hearing officer because we just don't really know how other jurisdictions address issues, their standards, their regulatory scheme.
Okay, thank you.
All right, next we have Vice Chair Alman.
It's my understanding that with the process that is set up for us, we're not here to relitigate any pieces of the decision nor the evidence. And my understanding is that the public health order was the Santa Clara County public health order, and that the hearing officer really did a lot of research into the dates and the possibilities of accessibility. I mean, I happen to remember when I suddenly was able to go to the Y and swim in one lane at a time, and it was very well regulated. And it seems to me that the hearing officer did a very careful job of assessing both sides. And it seems to me that it's only up to us whether we want to go ahead with the recommendation of staff of our attorney. And we shouldn't start looking way beyond and what are other jurisdictions. That's not relevant. The petition, there were I think 6 petitions submitted, and I think it's important that we narrow our focus and really look at what's here and make our decisions based on that. Thanks.
We have a hand raised by committee member Pardo de Zilla.
Council, are you aware of anything in the record that discussed or related to the issue of any additional costs, if any, that the landlord represented it would incur if it had to open the pool or the hot tub?
I believe you're muted, Miss Karen.
Sorry, that was brilliant and profound, but I'll try to remember it. I think that there was a reference in the landlord's response to the petition. I can't remember if it came up in the hearing. I will admit it was a lengthy hearing to review, but I think there was reference of concerns about increased costs of opening the second pool and having a monitor in that pool. But the health orders actually didn't require a monitor in all instances. Over time, what it required is a reservation system if the pool was unmonitored. And that was not really addressed in the information that was submitted by the landlord.
Okay, so my follow-up question would be, is there anything in that Golden case or the related cases that gives us any kind of guidance how to evaluate this issue, given, assuming for the moment that there would be an increased cost that would be incurred by a landlord versus a situation in which the landlord could continue to provide whatever service, but the landlord's not required to incur any additional costs?
There isn't. I think in the case law that I'm trying to think, that I do not believe that there is anything. I think in that instance, the relief for the landlord would be a petition for an upward adjustment.
Thank you.
Vice Chair Alman, you still have your hand up. Is that from the previous time? And,
Yes, yeah, it is. I'll take it down.
all right. Do we have any other questions from the committee for staff? Committee member Haynes Livesay.
Just a quick one. I tried to review the entire evidentiary record, but I could have missed something. Did we at any time know the square footage of the fitness center?
I don't believe there's information on the square footage of the fitness center, but I'm not 100% sure the health orders in July required a number of people per square foot. It was the pool that, one person per 300 square feet or one household per 300 square feet.
I thought
I
the
can't
fitness
remember. I
centers
could be
did
wrong.
for indoor. I thought it was
It
like
may have.
150 or 250. Okay, I was just curious. Thank you.
Yeah.
Go ahead, committee member Grunwald.
Sure. To follow on to that, is there in the evidentiary record, is there anything regarding the appellant's question about how, like, the calculations, how the calculations were for the pool were determined on what was on the rent that was not the square footage of the pool, but and do we typically ask that of a hearing officer to see their work, or?
I'm sorry, I think I missed part of your question.
Sorry, so I believe the appellant had said that there wasn't much evidence from the hearing officer's work to determine how the hearing officer arrived at $175 a month for the pool, for instance, as a compensation for reduction in services. I guess the question is to you, Karen. Did you see that, or is that affirmed that there isn't that work? And would we typically see that from hearing officers? Is that something that's expected, or is it just up to hearing officers' discretion?
So what the hearing officer looked at, there was a fair amount of evidence submitted by the petitioners of the costs to join other facilities that would have provided access to a pool. Those costs actually were, much to my surprise, much higher, quite expensive actually. And so the hearing officer used that as a basis and determined, you know, based on what was reasonable and based on the fact that there was some access, albeit very limited. So I think that some of the information submitted by the petitioners was like $360 a month. And the hearing officer awarded $175 a month for loss of the pool for a 4-month period. So.
Thank you.
We have committee member Partidizella.
So, counsel, I think there was an issue with an individual in the leasing office who initially had made a representation about some kind of communication with someone they believed to be associated with the city, who said that there were limitations on the pool use, I think, to a single family. And then from what I read in the record, it was later determined that perhaps that individual had erred associated with the leasing office, and it actually was an individual associated with the county. I think the name was Rios. It was a Miss Rios. And my question is, with the substantial evidence standard that we're supposed to be applying now, typically when we're dealing with this type of situation where you have somebody in the leasing office who is testifying that they had this interaction with a governmental official, and perhaps they were mistaken about whether that official was associated with the county or the city, but they're still representing that that official said that there were limitations on the pool use. Is that testimony from that individual in the leasing office, should that be considered substantial evidence on that point? Or is that something that we should, or the hearing officer should have essentially have disregarded because there wasn't any paper documentation, or that governmental official wasn't specifically presented to testify?
Well, I think in this instance, the hearing officer weighed all of the evidence. So there was that evidence. There was no information in the record as to when the conversation took place, who the conversation was with, and the basis for that conversation. And it was contradicted by the health orders, all of which had a different standard for use of the pool. And so the hearing officer gave the health orders a heavier weighting in the evidence and determined that that was the evidence to support the decision.
Okay, and then do you know offhand, and I apologize for putting you on the spot, but do you know offhand whether ultimately it was included in the record the identification and the name of this individual with the county who was not known initially but later became known? Was that something that was just argument later on in the papers, or was that something that became known to the hearing officer and part of the record at a later point?
It was not known to the hearing officer. It was only brought forth as part of the appeal.
Okay, thank you.
Right. Any other questions for staff? Going once, going twice. We will now, wow. Okay, so now we will have RHC members. Do you have any questions for either the appellant landlord or the respondent tenant? Committee member Haynes-Livesay.
I do have the same question that I asked Karen. I do have for our appellant landlord's counsel, if they're still available. Do you happen to know if you shared the square footage of the fitness center during the evidentiary proceedings, and or could you share it now?
Sure, hold on, if you just give me. So the square footage was the specifics with respect to the square footage was not discussed with at the hearing. However, there was a photograph that was submitted as part of the record.
Okay. Thank you. I won't ask you for it since it wasn't part of the evidentiary record, but I appreciate that information.
As staff counsel had indicated, I do not believe that the health orders related square footage to the fitness center, only to the pool area.
Okay. Perfect. Thank you.
Any other questions? Oh, committee member Paradizzella.
So I've got a question for Mr. Walker for the respondents, if he is still available for chance.
Yes, I am.
Did you or any of the other tenants at any point in the record make any representations to the hearing officer about how much any of you used the pool or the hot tub before they were closed? And similarly, did you make any representations to the hearing officer in the record as to how much you likely would have used the pool and the hot tub had they not been closed?
Yes, my recollection is there was pretty extensive discussion by a number of tenants about the frequency that we had used the pool in the past and that we would like to use the pool, but were precluded from doing so by the closure. I don't think that was in the form of evidentiary submissions. I think that was part of the very extensive hearings that we had.
Okay, thank you.
Any other questions to the appellant or the respondents? Seeing none, we can move on to the RHC will now deliberate. It will be appropriate at this time to entertain a motion to adopt the tentative decision, after which such motion can be discussed by the RHC. If there is no motion to adopt the tentative decision, then I will entertain a motion to adopt portions of the tentative decision. So we have 1 through 6, and Vice Chair Allman, go right ahead.
I would be willing to propose a motion to adopt the tentative decision. But that leaves it open for discussion, right?
Right, but we'll need a second. We do, screw it, I'll second it, so that we can talk about it. So that's the motion on the floor. Is there any concerns of why we are not adopting the whole tentative decision? Committee member Haynes-Lipsey.
So I don't have a weird obsession with square footage of buildings. However, for issue 2, in the evidentiary record, the health order, it is called LLX 13, North Westman, mandatory directive gyms and fitness facilities effective July 13, 2020, indicates on page 3, I believe it is. Oh, I just lost it because I moved up. Indicates the square footage. It's actually on page 404, density limitations for staff members, blah, blah. Let me get to the point. For clients, the limit is 1 person per 150 square foot of indoor space open to the public. That was my obsession there with the square footage. I swear I'm not just obsessed with square footage. So with that regard, I think that is part of the evidentiary record, since I was able to find it in the evidentiary record. And I'm not sure that it was reviewed by the hearing officer for issue number 2. So if we're remanding the decision, I'd like us to give specific direction that needs to be addressed. So it's not that I'm against the tentative decision, but I'd like to tighten up the language on the remand on number 2.
All right. I agree.
Was that an amendment to the
I
motion?
believe that would be a friendly amendment.
Does Vice Chair Allman accept the amendment? Vice Chair Allman, you are muted.
I do accept the friendly amendment. I think it's a great idea.
As a seconder, I also accept the amendment. I'm still having this open to discussion. If there are any issues with particular elements of this appeal, I am open to hearing more about that. Committee members Grunwald and part of the Zella, did you have any concerns?
I can go first. I think I'm just focused on the pool. I think I've narrowed in on the area of the decision that Karen was mentioning, with the Bay Club membership being a benchmark for how much the pool is worth per month. As part of the appellant's argument, I don't know. I was trying to ask whether, to what extent we can ask for more for not necessarily to say I disagree with the facts of the hearing officer's decision on the pool, but I just want more information as to how the hearing officer weighed some pool was still available from 11:30 to 5 every day. It is also a smaller portion. It's not everything you would get with a Bay Club membership, right? So just trying to figure out how the hearing officer did those calculations. That would be my only ask on remand is just a little more detail. If we are remanding other issues, that I'd like to see a little more of the work that they put into coming up to the 175 number.
All right, is that all for, okay. Committee member Parzella?
So, I mean, my primary issue is with numbers 1 and 2, and I do think there's a large element of this, which is really just looking back, with hindsight, which is 2020, and it's easy for us to, or the hearing officer to have opinions about what the landlord or the property management office should have done. But I think we all know the past year, nothing's really been predictable. A year ago, we were told 2 weeks, flatten the curve, and things are going to be back to normal, more or less. Nothing is gone according to plan. And I think it's very difficult for a lot of businesses to just evaluate this flurry of proclamations that come out from local government, from city government, from the federal government, and then be able to suddenly react and be able to plan ahead in an effective manner. And I think we've seen this issue with restaurants where they're told they can reopen, and then they reopen for 2 weeks, hire all the staff, and then they have to shut down again after 2 weeks, and they lose more money than if they had just stayed closed. So I don't know a lot about operating a swimming pool or a hot tub, but I tend to think there's probably a little more to it than just flipping a switch. And certainly there's a certain level of training of staff and their own protection that you have to be aware of when they're going to now be expected to a certain degree monitor people. Are they supposed to take people's temperatures when they enter the pool area or not? There's a lot of things there. So I think my main problem with number 1 and 2 in particular is just that it really is just looking back after the fact and holding the landlord to a standard that I think is difficult in real time for anyone to really comply with fully, not being able to see into the future. After the fact, it's easy, a lot of this. So I think then it comes down to, well, who's supposed to bear the costs? The landlords or the tenants. And I don't know that a lot of these cases that have been cited or recent legislation for that matter necessarily just impose on the landlord, all of these costs, that they're just supposed to be borne by them. And on the related point, I'm a little concerned about some of the evidentiary issues that have been raised. I mean, we have an understanding that this is supposed to be somewhat relaxed. This is a relatively informal process to present evidence. And if there's been a citation to newspaper articles that reference a public health order, in my mind, that should be something that's good enough to document that a particular public health order said what it said. And the fact that there's multiple instances where that's essentially been disregarded, and we're saying we're going to ignore that evidence, to me seems a bit unfair, especially when there are other instances where it seems like evidence was very just liberally granted and admitted without a whole bunch of weight behind it, a huge amount of foundation. So that's my concern, essentially, that the evidentiary restrictions have been a little more against the landlord, at least in the record that I've seen, and that secondly, we're essentially holding the landlord to what's an impossible standard, given what they knew, what we knew, what the county and the city knew at the time all this was happening, which is, I think, how we should be looking at this, not as we're sitting here today, 6 months later or 2 months later, and second guessing things from the comfort of 2020 hindsight. Thank you.
Can I respond just to one issue? So I just want to make sure the record's clear. So there were no newspaper articles submitted as part of the record. The appellant landlord did reference a newspaper article in the appeal that is not part of the record. And in part, the decision to remand was in part based on that newspaper article, because if they really could not open the fitness center, I think that needed to be considered. But there is nothing in the record at this moment that supports that newspaper article, and that newspaper article isn't part of the record. So that, I think, is the only newspaper article. But, you know, frankly, for the tentative, I did think if they could not actually open the fitness center, that needs to be considered. Despite the fact that the appellant landlord was given ample opportunity to submit evidence to that effect. And in fact, the evidence in the record says the opposite, that as of July 2nd, they could have opened it for limited access, but they could have opened it. So that's why I think it needs to be remanded for additional evidentiary findings.
Thank you, Ms. Karen. Committee member, Vice Chair Alman.
I don't know if I'm getting into relitigating, but I remember one of the things that I was impressed by was the fact that the property management or the landlord decided to limit the hours to 11:30 to 5, and it had always been open at 8:30, and the office was open at 8:30, and the office overlooks the pool. So it does seem like a real restricting. I mean, if you're going to allow, even if you were going to do the one family at a time, if you've only got, 5 hours, that's not very many people a day. So I kind of feel like there's a legitimate case. They're not saying that this is for, a whole year's time. They're only restricting it to the summer months in which there was a reopening of pools. And I know for me, in every apartment I've ever been in, I swam practically every day. So it would be a real loss of services. Anyway, I feel that they make a good case on that one.
Committee member Haynes-Lipsick.
With regards to the pool, since that seems to be where we're staying focused right now in our discussion, in the evidentiary record, Landlord Exhibit 12, this is the directive from Santa Clara County. It is quite clear, and I believe this is cited in the hearing decision as well, that all, an emphasis as I try and do this, is indeed from the piece, all shared outdoor pools except unstaffed residential pools, meaning pools in residential complexes that do not have staffing at the pool area, even if they have staff on site other places in the complex, like a lobby desk, must have at least one person separate from the lifeguard on duty at all times to make sure that all rules in this directive are followed. My understanding of the hearing decision rests on that line of the Santa Clara County directive, specifically that since this was an unstaffed pool, there was never any requirement or expectation that there would be expenses associated with staffing these pools and supervising compliance with the directive, because the county was not mandating that to be in compliance. Furthermore, I do believe that the county made it quite clear that they only expected businesses to comply with their orders to the extent that the order forced compliance. They did not expect businesses or individuals to do other levels of supervision of the directives. I believe that there was a phone number, or there may still be a phone number that one can call if they feel there's a violation of an order, and the county will deal with it, and the county is tasked with dealing with it. So I think that for item 1, issue 1, the reason why the decision, my understanding of why the hearing officer made the decision that he did in terms of granting some sort of rent relief there, was because both pools could have been open without supervision, without added expense. Now, granted, you could argue perhaps that setting up an online reservation system could have some level of expense because you have to pay the coders and all that stuff, but that you could have opened both pools without any added expense because the county was not forcing supervision of the pools. So I think that's an important component on item number 1, is that the orders did not force that supervision. That was a choice being made at the time, potentially by the landlord, to say, if we're going to open the pool, we feel that supervision would be needed. Perhaps we can't deliver that, or we don't feel comfortable delivering that, or we don't feel we're trained to deliver that. Ergo, we're not opening the pools completely. So I just wanted to clarify that.
I had a question for Ms. Karen in relation to committee member Grunwald's question about, is it possible to still affirm number 1, but still ask for, like, where'd you get the numbers?
You would have to remand it back to the hearing officer to, I guess, reconsider the actual number. I'm not sure what the actual remand would be. You would need to make a decision as to, is it a remand solely to further support the numbers, or is it a remand on the entire issue of access to the pool, et cetera. So you would have to give some direction on that. And then, of course, it could come back up for appeal, et cetera.
I mean, I'm comfortable with affirming it. I do want to be able to satisfy the essential justification that committee member Grunwald would have liked. But I am okay with just affirming it. I don't know how much more time it will cost for the hearing officer to do that. I guess that's also something to think about. We are remanding 2 items already, but I don't know if there's an additional thing for something that I'm just willing to affirm now. I don't know if that makes any sense. I guess it's just the decision of whether we do want to spend the extra time on that, or perhaps when we remand a decision for number 2, we could ask the hearing officer to be clearer on his numbers, and then we can see or extrapolate from there how he got the pool numbers. Would that be sufficient, committee member Grunwald?
I mean, in general, I think the evidence is there that, the landlord maybe did not respond as quickly as they should have. I think I hadn't actually, maybe I'd read to Nicole's point about it being hot during those months. I mean, that's a legitimate, you may not be using a pool all year, but like you really do depend on the pool for those certain months. So I can't remember if I read that in the evidence. I don't want to insert new evidence, but really just holding our hearing officers to a standard of when he mentions when the hearing officer mentions June 4th as being that start date, I feel like you have like, but for the other parts of the decision where there is a reasonable amount of time, I mean, if the decision comes down from the county, it takes time to process that to get a reservation system up. So there's some sort of grace period there. And then I agree, the second pool wasn't opened at all. You know, I just want more detail. It may come out to be the same number, and I'm relatively supportive of like there seems like there wasn't all the services weren't kept. Just more logic behind how that decision was made.
So
sorry for the ask. I would. I guess I'd be open to the numbers changing if I want to give the hearing officer that flexibility. If we are remanding the other items, I definitely don't mind paying for the additional time. I think because it comes from us, right? It wouldn't go on the appellant or the tenant. So, you know, it's our cost. I'm interested to see, you know, how the hearing officer would flesh that out. So I'd be open to a remand and then agreeing with what they come up with. Sorry, does that answer the question?
So would you like to make a friendly amendment?
Yes, and Karen, maybe some help on the best way to make a friendly amendment that captures the essence of what I was mentioning.
So I guess my question to you, is this solely a remand on the determination of the amount of the rent reduction on the lack of pool access? If that's the case, then I would suggest that you affirm the hearing officer's decision on the appropriateness of a rent reduction for lack of pool access for the period from June 5th to September 30th, 2020, but you remand the decision to the hearing officer to provide additional evidence or support for the basis for the dollar amount for that rent reduction.
Does the motion maker, is that your amendment, committee member Grunwald?
Yes.
Does the motion maker, Vice Chair Almond, do you accept that amendment?
I'm a little confused. Are we amending number 1 or number 2?
Number 1.
Number 1.
Okay.
The amendment would be to affirm that there would be a cost reduction, but the remand would just to be double checking if the numbers are correct. Now, he could come back with the same numbers. It sounds like committee member Grunwald just wanted more evidence on why those numbers were decided.
I think that what we're asking is a justification for the specific dollar amounts and what was the basis of that, right? I guess that's okay. I mean, I was willing to accept the dollar amount. It seems reasonable to me, but yes, I'll accept that as a friendly amendment.
Did I represent your amendment correctly, committee member Grunwald?
I think so.
All right, then I also accept that amendment. And so I think.
Well, I do have another question. Are we asking him simply to give us the basis of that dollar amount? Is that what we're asking? Because I don't want it to open up a whole new can of worms about, well, maybe we should up the amount, maybe we should lower it. You know, that could be a lengthy process. So am I understanding that we want to know where he got his numbers?
Yeah, I would like just a rationalization just to see more of the work. I was open to, you know, if the hearing officer came up with a different number, but I'll accept the will of the majority, you know, on that one.
Thank you.
All right, so that has been accepted, Vice Chair Almond? Just making sure.
Yes.
All right, I have a hand up from committee member Haynes-Livesay.
I just wanted to say quickly in support of that amendment that this remand may be helpful in clarifying the pool, hot tub, fitness center quagmire, because we've heard from Mr. Walker that the pool and the hot tub were sort of unified as the pool amenity in the mind of the tenants.
Mhm.
So perhaps by getting more clarification on the figures, we can really understand if the hot tub was included in the pool calculation or included in the fitness center calculation, perhaps included in both calculations by error, or what the case may be. So I just wanted to say that's another benefit of that remand.
All right. And with that, I don't see any other comments. I'm going to call the question. So, Miss Andrea, can you please call the roll call vote for it was a very long time to get to this motion, but I'm going to try to summarize this motion the best that I can. So the motion was to accept the tentative decision with slight changes to issue 1. Was there another one, committee member Haynes Lipsey? Oh, and
Yeah.
some modifications to, a limitation to issue 2. Is that correct?
Yes, just when looking into whether the fitness center could have been reopened at all, attention be paid to the square footage requirements in the health orders at the time.
Did staff get that? Once staff has gotten the proper motion, please proceed with the roll call vote.
Okay, I will begin with committee member Pardo DeZella.
Based on Nicole's helpful information, yes.
Committee member Haynes Livesey.
Aye.
Committee member Grunwald.
Aye.
Vice Chair Almond
Aye.
and Chair Ramos.
Aye.
All right, so the motion passes unanimously, 5 votes to 0.
Woohoo. And I guess that is it for the script for the appeal hearing. We are going to take a brief break before we enter our next set of business, which is 8.1. So I'm going to call a 7-minute break because it's 8:58, and we'll reconvene at 9:05. So have fun, y'all. Don't say anything you don't want to be heard because we're still live. All right. So it is now 9:05. Let's see if we have everyone. Oh, I think, oh, there he is. Okay. All right. It looks like we have everyone. Let's go. So we are now at 8, new business, 8.1, capital improvement petition process study session, and we have a staff presentation.
Good evening, committee members. Thank you, Chair Ramos. Item 8.1 is a study session about capital improvement petition process. And the recommendation is to receive information and consider potential policy options related to the capital improvement petition process for temporary upward adjustment of rent. And specifically tonight, we'll be discussing recommendations related to the share of costs in our policy options. And I'm going to go over just a lot of high-level stuff really quickly to speed us through the conversation, as well as review some of the decisions that were made at the previous study session last month, just as a mental refresher. This was also provided in the staff report and as attachments. So as you know, the CSFRA stabilizes the community by reducing rental housing turnover, and it does that with 3 main pieces of policy. 1 is stabilizing the rents, 2 is providing eviction protections, and 3 is this final one that we're focusing on today, which is ensuring a fair rate of return on investment. And to go into goal 3 a little bit deeper, we have some different mechanisms to achieve a fair rate of return, and that includes the annual general adjustment, which this year is 2.9%, vacancy decontrol, that's our major one, and 3, individual petitions for upward adjustment of rent. Right now we have the fair return standard, and tonight we're looking at another option for the capital improvement petitions. The RHC has the authority to promulgate regulations to establish rules and regulations for the administration and enforcement of the CSFRA, implement the petition process, and provide landlords with a mechanism for achieving a fair rate of return that addresses individualized circumstances. The capital improvement petition process allows landlords to recover costs of certain capital improvements without providing extensive records as required in the fair return petition. Deferred regulations have been deferred due to Measure D originally, and the committee had requested staff come back after Measure D did not pass with regulations, and we did that in August. So just as a reminder, regulations have already been drafted for this process, and we will be able to amend what has already been worked on by staff with your guidance to get this up and running relatively smoothly. On January 25th, the RHC had a study session where you provided feedback on policy options and requested an additional study session, and that's where we find ourselves tonight. And tonight we will specifically be looking at what you requested, which was recommendations related to the share of costs allocation. Now, as a reminder, capital improvement petitions encourage landlords to proactively maintain their property. They promote safe and healthy housing for tenants, which is one of the main goals of the CSFRA. They reduce potential large-scale displacement, and they preserve the affordable housing stock in the city. The CSFRA limits capital improvements to improvements that are necessary to bring the property into compliance with the applicable codes and cannot include costs that could have been avoided by the exercise of reasonable diligence in maintaining the property. Specified capital improvements are those major capital improvements that significantly extend the useful life of the property, and they must already meet the definition of capital improvements that are part of Chapter 6 of our regulations. And we will be covering this set of topics here. I would like to remind you that you've already given guidance and specific policy options have been determined for all of these areas. So our policy basics, capital improvement petition process itself, as well as the administrative hearing process, the major qualifications, categories and authorized expenses, documentation, and amortization and sunset periods. The piece that we're looking at tonight, again, is Area 6, the share of costs. So this is what was agreed to last month for our option Area 1, policy basics. And you'll see here, you gave guidance to staff to make sure that the regulations have information that is very specific, including specified capital improvement fair return standard, the length of increase, which is a temporary adjustment to recover the authorized costs and ends at the end of the amortization period or at vacancy decontrol. The increased parameters, including that this is not considered rent as defined under the CSFRA and therefore is not included when calculating the AGA. So the AGA would go on to what would be considered like almost like a base rent situation for the calculation of the AGA. And its pro rata allocation to all units benefited. And tenant hardship petitions are allowed. Policy Area 2 is the actual capital improvement petition process. So this is the administrative petition process that we talked about last month. And if a hearing is requested, a hearing will be held. If a hearing is not requested, then it will go through the administrative process. And if it's not appealed, the decision would be final. And we have our major qualifications here that you agreed to last month, as well as the exclusions, and these are similar to those that are already in place for our general capital improvements that are provided as part of our MNOI petition process. And we also have here that they must appreciably prolong the useful life of the property, and as requested by the RHC, have a useful life of more than 5 years in line with our amortization schedule. And that the capital improvements that adhere to the above qualifications and also improve the environmental sustainability of the property while reducing cost of tenants may be considered as improvements that are eligible for the expedited petition process. We have our exclusions. These are from our current regulations and also fall in line with what is required under the CSFRA itself. And I'm not going to go over them today. They are in multiple documents for your review. We can always come back to them should you want to review them again. Policy Area 4 was consideration about categories and authorized expenses. You'll see here that the categories are kind of like the big buckets, and the authorized expenses are the more refined ones. As requested by staff, by the RHC, the staff will request code applicability from appropriate departments as necessary, and we will provide guidelines that outline certain categories that are anticipatory or placed in the expenses in anticipation of future code regulations, and assist petitioners in the petition process to ensure that that what they're requesting falls in line with the requirement that it's code applicable. Area 5 is documentation as requested by the RHC. We have added in permits here. And then Area 7, so we're skipping 6 because 6 is what we're talking about tonight. Area 7 is amortization periods and sunset periods. The amortization periods were approved as presented in Authorized Expenses and Amortization Schedule B. Staff did look back at what was in the amortization schedule in relationship to fire suppression specifically, and there is line items in that amortization schedule that clearly spell out what type of fire suppression, alarm system, sprinkler is being amortized. And then the expense sunsets at the end of the amortization period or at vacancy decontrol. So again, we're looking at Area 6 here, the share of costs. And staff did a review of the amount and type of properties and units that we have. And you can see here we're proposing a 3-tiered system based on property size. We have properties with a number of units from 1 to 5. That's 299 properties. So a sizable portion of our rent stabilized properties fall into that, but it's only covering 1,081 units. And for that group of properties, which are our small landlords, we are recommending that there's a 100% proposed share of costs on the tenant that is capped at 10% and inclusive of that year's AGA. Again, the AGA is not calculated on that. It's calculated on the base rent and is amortized according to the schedule, with hardship petitions being allowed. And I want to clarify that this represents 43% of fully covered properties and 7% of covered CSFRA units. Staff also looked at the ownership records for this, and it consists of the greatest number of owners with two or fewer properties. The next category for property type is type B, for properties that have 6 to 20 units. That represents 251 properties, which is 36% of our fully covered CSFRA properties, for a total of 18% of our units. And it consists of a large number of owners with 3 or fewer properties, but does have an increased number of corporate owners over the 1 to 5 unit properties. And for that, we are suggesting a proposed share of cost at 75% to the tenant, 25% to the landlord, capped at 10%, inclusive of the AGA, amortized according to the schedule that you agreed to last month, and having tenant hardship petitions allowed. And then type C is for units, properties with 21 or more units on the property, which represents 143 properties, but 11,124 units. So that's 21% of our properties, but 75% of our units. And the ownership records show that it consists of primarily multi-property and or corporate owners. And for that type of property, we're recommending a 50% tenant, 50% landlord split, capped at 10%, inclusive of the AGA, amortized according to the schedule, with tenant hardship petitions allowed. So we actually have 3 models tonight that I wanted to show you based on costing. Staff went ahead and did some research for this. Model 1 actually happens to be a current request that came into the Mountain View Rental Housing Helpline, and is actually showing what the costs for replacing windows at this particular property would be. And this is a situation where both the tenants and the landlords would like to see this improvement happen. And so for this, you'll see the cost breakdown. We have a $15,000 total repair for a 5-unit complex, and it works out to being $50 per month, which sunsets at the end of 5 years. For a 10-unit complex, it would be $37.50 per month, again sunsetting at the end of 5 years. And for a 30-unit complex, it would be $25 a month, sunsetting at 5 years. The next model that we have is based on market research for fire suppression systems by property type. And it approximately would cost about $9,153 for a 3-unit complex. This breaks down to $12.71 per month. For a 15-unit complex, it would be about $9.53 per month. And for a larger complex of 100 units, it would break down to $6.36 per month, based on the costing exercise that we've done. And then finally, staff went and looked at a previous batch of petitions where we had a petitioner that had a capital improvement expense on their M&OI petition. And this is the one that's not in the staff report, but we pulled the numbers today. And we were able to do some just basic costing on this. And you can see here, it's a larger expense of a repair on less units. For this top one. So it's a $60,000 total repair, which breaks down to $83.33 per month. And for the 1 to 5 unit costing, For the 6 to 20 units, it's $62.50 per month. And for the final group there, which is about $1.5 million expense, it would be $41.67 per month. And staff would like to mention, let me just reference some of my other numbers here, that given the average market rent currently in the city, anything under $238 a month is less than the 10%. So these all fall under that. If we're looking at it inclusive of the AGA and thinking about it as a 5% breakdown of, we could end up having an AGA that's 5%, which would cap everything at 5% for a repair. While it's still, all of these costing scenarios still fall under that. That max is $119 a month. So you can see the way the different scenarios work within the market as well. And that is the staff presentation for this portion of the evening. I did want to also show you, while we're here, before we get to questions, there had been some concern about making sure that when we went into looking at a costing model, that it would be easy for a petitioner to fill out and understand how the math would work. And staff is just going to show you an example of what we've been working on for our MNOI petition. And you can see here, there's some funny things happening in my spreadsheet right now because of Zoom, but we'll work with it. This is what our capital expense worksheet looks like to figure out how this breaks down in an MNOI petition. Everything is built in to do the calculations automatically as the petitioner is filling out the form. So all of the math actually auto-calculates everywhere on this spreadsheet. And we will be doing something similar to that for the capital improvement petition. So if you were filling out the petition, you would not have to figure out the 50%, the 25%, the 75%. The worksheets would do it for you. And obviously staff is here to provide the support and assist with that as needed. So that is the end of staff's presentation, and we're happy to take questions at this time.
Do we have any questions for staff? Don't all jump in at once. Committee Member Grunwald.
Sure. I think we had a write-in question that I thought was interesting regarding, if this is not rent, will this be captured? Do we have the flexibility to create new fields in our rent registry to account for this? If we don't get to that level of detail, it's more just, or will we be able to handle the change and still not flag anyone as being over their 10% if, or I guess if the 10% is inclusive, then that may be a moot point. But sorry, long story short, can we handle this with the rent registry if we were to implement it?
We definitely can. It's a field that we could add, and it's also a field that the ability to handle petition increases is something that we have taken into account with the vendor. So it's definitely something that we can work into the current system, as well as having this batch of type of petition, just like the joint ones that were discussed last month, be included as accessible through the portal. That is something that we'll be able to do as well.
Great, thank you.
Committee Member Haynes-Livesay.
Yes, we seem to have a write-in about the joint petition process as well. Just bear with me. Was that different than what we had previously discussed, or just someone supporting it? Because it seemed like it had a little bit more intricacies in how the write-in letter was positioning it versus what we discussed, but maybe I was wrong.
I think there may be a little bit of confusion between the two types of petitions that we're discussing based on that particular correspondence. However, we have received support for both types of petitions, either through the helpline or through the correspondence that was received.
Awesome. Thank you.
Any other questions? This one's a minor thing now that I saw the wonderful spreadsheet, and I do love spreadsheets, but is that only available to people who have Microsoft Excel?
So we're still working on building that, and people who are petitioning can, if they do not have access to Excel, they can work with me and I will help them with that. So we can sit down just like we would in person, or we would have in person. They could sit with me and we could work through it together. I can share my screen to be able to help them with that. So it's definitely something that we have the ability to work with if they do not have access to Excel. And as we move forward, we'll see the ability of whether or not the system is capable of doing some of those calculations. However, we're pretty confident that the Excel workbooks will be the best way to integrate the petition and its calculation challenges with our current portal system. And it's also the most commonly used for jurisdictions that do provide a supportive workbook like that, of which will be few in the good grace of the few that have that option. We will be joining those ranks. So it's definitely a improvement over the current ones where you have to do it by hand, and that leads to more errors. So,
okay. Do we have any other questions? I see head shaking, shaking. Oh, Vice Chair Allman, you're muted.
I really appreciate the report and how it lays out the different tiers. My concern is for the tenants that are in the smaller ones. They're sort of penalized for being in a 5-unit. Their costs are going to increase exponentially more than in the big corporate complexes, and it doesn't seem fair that if you've lived in a mom and pop landlord system that you've been there for 30 years and all of a sudden they want to do some major capital improvements, and you're going to get dinged way more than anybody in a complex of 350 units. I don't like the fact that we're saying 100% of costs can be passed through. And I guess I should have spoken up more last time, but it just doesn't feel fair to the greater population that we're supposed to be protecting.
If we have no other questions, I'm going to go to public comment. Would any member of the public on the line like to provide comment on this item? If so, please click the raised hand button in Zoom or press *9 on your phone. The speech timer will be displayed on the screen. And we have one hand raised, 2 hand raised. I'll start with Edie Keating.
Hello.
Go ahead, Edie.
The staff report divides this agenda item into topics where adequate input was already received, and one additional topic where, as we're already starting to hear the questions, that it will be discussed tonight. The comments I made in the prior month still stand. I still think that the exclusion of capital improvements which are not required by code is clear and important. And when I look at the amortization list, I still see items that I do not believe are required by code, such as adding solar to existing buildings or adding air conditioning to existing buildings. I cannot believe that there's code that requires this. So shouldn't those items at least get an asterisk that says they would need to be required in the future, or perhaps removed from the list? Moving on to tonight's focus, I generally support the categories that are described in the staff report. However, even the smallest landlords should have some share of the cost of capital improvements. At least 5% or 10% of the share should be carried by the landlord. With 100% carried, landlords could know that they would have no say in improvements and would just, have a shopping list of what would they want to improve their units for without having to bear any of that cost. I think that is a incentive that you don't want to provide. The landlord needs to have some share in the cost. I am not clear what 10% inclusive of AGA means. I would think that from year to year, does that change what the cap would be? Because AGA can vary, but is this going to be a fixed cost set? And then in future year for the capital improvement, in future years, would there be the chance of going over 10% if there is a higher AGA? Interest is excluded from the CSFRA fair rate of return calculations in the ordinance law. And so I was confused to see interest included in the model spreadsheet. So I'm just unclear about that. Thank you.
Thank you, Edie. Next up, we have Alexander Brown.
Emily,
Yes.
Would it be okay to have staff respond to a few of those questions directly, or should we wait until the deliberation period?
Whatever staff is comfortable with. Would you like to respond to those questions, staff?
I think in particular, some of the ones that were just clear-cut questions about, like how would it work if it is, since the AGA is variable from year to year, but the initial cost of the capital improvement is fixed. How would we handle that one? Oh, sorry, that was a or Anki, like would we just want to handle that in the deliberation period? If you want to wait until then.
Yeah, let's wait until the deliberation period.
Okay. Thanks.
We'll continue on to the next public speaker, Alexander Brown.
I mean, I was just going to say I totally agree with Edie's concerns, and I think that we should make it very clear what is and is not an allowable capital improvement expenditure before the landlords do discovery and start pricing things out. And also, yes, that there does need to be, the cost sharing cannot be wholly on the tenant, because if that's the case, why is the tenant paying for their property without getting any ownership stake in the property? That doesn't seem fair. But also, nice spreadsheet. Good to see technology being used to make lives easier.
Thank you, Alexander Brown. We will bring it back to the committee for deliberations. So I guess the first thing we probably want to do is if staff could answer those questions that were addressed during public comment.
And specifically the question is?
I believe the question was about the variable AGA and how you would present with the models, how they will pay this certain amount every month for 5 years. But during those 5 years, the AGA could be different. Although with the examples that you did show, it's assuming even if the AGA was 5%, it would still be under that. So I guess that's kind of a moot point there. But as we get to, we're looking at edge cases now, like the point where it is going to be, where it could be at the 100 and something dollars a month or 200 something dollars a month. How will we deal with that?
So there are additional qualifiers you could put on this, such like what San Francisco does, where they have a dollar cap as well. You could also look at it as a 5% cap across the board, not inclusive of the AGA. That would address this issue as well. Otherwise, it's assumed that it's that, that it's basically a one-time increase that continues for 20 years. So whatever the AGA is after that is not taken into account. But you do have different ways of addressing that concern.
Thank you, Patricia. Committee member Grunwald, were there any other questions from the public commenter that you wanted to address?
Give me a second. I can't, I need to, I think she also submitted something online, so I'm trying to go through that line by line to see if that's all been answered.
All right, I'll move on to Vice Chair Alman. Vice Chair Alman, you are muted.
Sorry about that. Brilliant. The item of interest being included, if the CSFRA specifically does not allow interest, that seems like something we could correct before it goes into the regulations.
I believe that it does not include debt servicing on mortgages, and that is different than interest on capital improvements and loans that are taken out specifically for that purpose. It is currently in our M&OI petition as part of the costing breakdown. So it's something that has been in our calculations for quite a long time.
So we already allow the debt, say you put in a solar system, the debt, the loan that you take out.
The interest on that loan is part of the calculations for capital improvements at this time.
I see. Okay.
And that is, the CSFRA is really clear. It's interest on mortgages, and that excludes interest on capital improvements.
Okay.
So interest on capital improvements is allowed, is what Karen's saying.
The prohibition on interest excludes prohibiting interest on capital improvements. It's a double negative.
Okay.
Is that all your comments, Vice Chair Alman?
At this point, yes.
All right, next we'll go to Committee Member Haynes-Livesay.
On Edie's questions, I believe one of the things that she pointed out was, I think, Patricia, there remains some confusion on the two schedules that are attachment 2. One is the code-based, and the other one are specified capital improvement petitions. I think that's causes some confusion when folks look at those two schedules. So maybe if you want to run through what Schedule 1 versus Schedule 2 are for again, that may answer that question.
Schedule 1 is for our M&OI petitions. It allows for more improvements than Schedule B, which is for the specified capital improvement petitions. They're both code specific because our whole law does not allow for capital improvements that are not code specific. And Committee Member Grunwald had asked for a clarification on that, and how staff is looking to address that is through specific guidelines in our instructions about some of these are in anticipation of future code updates, just the way that some of them are in anticipation of future code updates in our current schedule for our M&OI petitions. The M&OI schedule has been around now for about 4 years and does provide leeway for hearing officers' interpretation for the capital improvements in the same way that this would. So a petitioner would come to us before they've made the expense in most circumstances and say, is this approved? And we would be able to give guidance on that. And this allows us for that flexibility as the codes change, to not have to come back to you and say, can we add this to the schedule? It's already there, and we can provide guidance to the public on how it can be applied appropriately.
Thank you. I appreciate it.
Committee Member Grunwald.
Thank you. The other item that I think Ms. Keating reminded me of was vacancy decontrol, and I just wanted to clarify that when the initial calculation is done for, let's say, a roof, that monthly calculation will be made. That will be the max that a landlord can, increase anyone in the building, but would not be forced to increase. They would then be able to choose who gets that increase, right? Because some members would already be at market rate, and so they let's say in between when they started replacing the roof and ended it, there was turnover. Just to clarify that the landlord would not be forced to add it to everyone's bill, and then as units turn over, then those units no longer have there's not that consideration anymore. I'm thinking about that correctly?
The tenant has to be in the unit during the time of the repair, correct, Karen?
Yeah, you cannot impose an increase for capital improvements that were installed before the tenant occupied the unit. And that's how that vacancy decontrol issue is accounted for. So when the unit turns over, the capital improvement increase goes away, the new rent is set, and there isn't a capital improvement increase. And if somebody were to move in, let's say a roof installation, and somebody moves in immediately after it's completed, they would not be subject to the increase. But the increases have to be allocated amongst all the units that benefit, regardless of whether all of the units are named in the petition because of that vacancy decontrol. So a roof, generally it's the entire building. But there will be some units that will be allocated the increase and some that won't. But the cost will be allocated amongst all of those units that benefit regardless, so that it's evenly applied.
Right.
Just to clarify, Matt, yeah, so the calculation needs to be over all the units that benefit. Whether a landlord decides to actually put that rent increase on their next bill, that's up to the landlord.
Got it. Thank you.
Yeah.
We have a hand raised from Vice Chair Allman again.
Yeah, I was just wondering, in the major complexes, you've got lots of buildings, right? And say one building needs the roof repair and others don't. Is the cost sharing spread through all 350 units, or is it only the unit? Okay, that's an obvious no.
Yeah,
okay.
The building that's impacted.
Right. Okay.
Committee member Haynes Livesay.
Do we want to discuss the idea of the cost sharing for Group A? And it sounds like there may be some hesitation to have the 100% tenant cost share there. What would we, if there is indeed a hesitation, what would be a more comfortable number for everyone?
So the next level down would be at 75%, correct?
Yes.
So would 10% sound good to people? It's basically, I believe the whole purpose of that is essentially for a skin in the game kind of argument kind of thing. Now, would 10% be too much, too little? What we wanted to do was make sure that, because smaller landlords are do have more difficulty in recouping costs, unlike bigger landlords. So that was our logic for having a different tier system. But I guess the 100% I think is giving some people some pause. So Committee Member Grunwald, your thoughts?
Sure, thank you. Yeah, I mean, we had last meeting, we had several options put in front of us, and my intent on asking staff to bring this back with a recommendation was, there's a lot of different things that are done across the jurisdictions, and I wanted to see what their unbiased opinion would be coming back. And for this, I do kind of agree. I think the intent for the smaller landlords was you have a higher likelihood of being essentially, if you have 5 long-term tenants in a 5-unit building, that you're more impacted, I guess, by having to do some of these capital improvements, as opposed to rent control in general at CSFRA is predicated on newer tenants supplementing or subsidizing the rents of longer term tenants. And you're just more likely as a small landlord it's kind of random, and you may have more longer term tenants. And I think that was the intent here, was to give them more leeway on big capital improvements that may take a heavier hit, because we did hear from smaller landlords when they would come in to say, I hadn't raised the rent in years, and now we're coming up on, we need to replace a roof or do something like that. So I think that was the intent, and I do like. I guess the question to staff is, in that defense, is this what is the norm across other jurisdictions? Did you use other jurisdictions as a basis for making this recommendation? Do you have any additional information on how you came to the 100% for small landlords versus the other tiers?
Staff took into consideration the request to not have things be overly complex as well, which was made at the last meeting, and reviewed the different jurisdictions and different options. And this seemed to fall into a blend that took into account all of the different considerations that had been requested. Again, it's something that can easily be adjusted and amended in a spreadsheet to do the calculations, so that if it was a 90-10 split, that math can be done so it's not burdensome to the petitioner. Again, we've reviewed all of the other jurisdictions, and based on that and the type of unit breakdown that we have, and taking into consideration the different considerations that were requested at the last meeting, this is the recommendation that staff landed on. However, we're happy to amend as needed. Again, the other jurisdictions also have a dollar cap on their a monthly dollar cap on their increases. So you see something like this, which in somewhere like San Francisco is 100% for small landlords and 50% for larger landlords, which is what staff brought at the last meeting as one of your options to consider. We broke it into 3 tiers based on those property ownership records and the number of units impacted. So those pieces were taken into account on top of what was looked at the other jurisdictions.
So we want things specifically tailored but simple. Sounds easy, right? I guess the 100% is something that should probably be discussed, or we can look at different caps. Instead of capping at 10% inclusive of the AGA, I did like the idea of the 5% cap, or just a hard dollar cap. Anyone have any thoughts or preferences on how we would go forth with that, Committee Member Grunwald?
Staff would like to mention briefly, we're not covering it today, but in the joint petitions, you did agree to a 5% cap across all types for simplicity. So that is something that you could do here and make it not inclusive of the AGA, and that would have some consistency between the two if you so choose.
Thanks. I was just going to say I would strongly recommend against a dollar cap, just because of maintenance issues that we'd have to update it. Does it go with CPI? So percentage. If you're going to go with that option, then I go with a percentage.
All right. Next, we have Committee Member Partizella.
Yeah, question for council, and this might be an unlikely scenario, but would it be possible if we adopted this, if you had, for example, type B and you had a property that was only 6 units, that an owner would be motivated or be in a position to take a unit out of service or otherwise remove it so that it's essentially deemed a type A property and they would be able to shift all of the costs to a tenant to 100% rather than the 75 they would have if it was a 6-unit property. I'm just trying to figure out if there's a way that people might try to game the system, which I think we all would.
I can kind of give some experience where previous properties in Mountain View have to demolish a unit or two, and that by itself is already like a long process to get your permitting done. And I do think this system is meant for the number of units that are on the property, not the number of units that are in occupancy.
Right, and you can't, like under the LS Act, you can't just take one unit out of the rental business. You have to take the entire property. So, you know, I think there are enough guideposts or restrictions that would make it, you'd have to really, really want to avoid this to make it work.
Thank you.
I did have a quick question. It might just be because 1 and 2 unit properties aren't covered in the CSFRA, so type A is really 3 to 5 units.
We actually do have single family homes that are on properties that are covered by the CSFRA, which is why this includes 1 unit properties.
Oh. Okay, cool. Committee member Haynes Losey.
So I actually I wanted to ask the question about the 100% because I actually think a 90-10 split is the right way to go. So I would be supportive of that. I agree with Matt's comment. I really don't want to see us use a dollar amount. I think that using a dollar amount is just creates obstacles down the line that are really not going to be worthwhile. If we wanted to do a 5% cap, I could see us doing that. I don't think based on the models that we saw that it would really impede cost recovery in any material way that undermines the goal of this whole petition process. But I also am fine with using the capped at 10% inclusive of AGA. So, but I think the 90-10 makes sense.
All right. So do we have, there's no real motions that we are going, this is still kind of a study session, isn't it? So why don't we just do a quick straw vote for whether or not we do a 90-10 split. I do have a hand raised by Vice Chair Allman.
Are we going to be considering the issue of capping it at 5%, which I would be for, or are we considering the 90-10 in this straw poll?
I think we're just going to do the 90-10 now, and then we can do another vote on whether to change the cap at 10% inclusive of AGA versus a 5% general cap.
Okay.
Okay, so let's do a straw poll. I don't even know how we would do a straw poll on Zoom. I guess we could do a roll call straw poll. Let's do a roll call straw poll. So the question is changing the type A from a 100% cost share of the cost of tenant to a 90-10 split for the tenant and the landlord. Andrea, do you mind calling a brief roll call straw vote?
Sure. All right. Let's start with committee member Pardo DeZella.
Believe it or not, I do not have a strong opinion on that, so I would defer to everyone else on that.
All right. Let's go with committee member Haynes Livesay.
I like it. So yes.
Committee member Grunwald.
My preference is staff recommendation to keep it as is. Nay.
Vice Chair Almond.
Oh, I think it's still too high for the tenant, but if that's as much as we can get, I would go for the 90%.
Chair Ramos.
I'll also accept the 90%, 90-10 split.
All right, so I suppose the straw poll passes. 4 votes to 1.
Does the
Not
staff
sure
have what they
how
need?
that's worded, but there we go.
As long as staff has what they need for that question.
We do. Thank you.
I still have a hand raised by Vice Chair Almond.
I'd like to consider capping it at 10%, at 5% instead of 10%, as a friendly amendment to our chart.
And not inclusive of the AGA.
Right.
Because I do believe that was the point, having it 5%, because the AGA will never be higher than 5%.
Just a clarifying question there. I mean, how would rollovers come into play potentially? Maybe it's a question for Unky, maybe, or.
Can you clarify?
So if you're carrying over an AGA that you haven't, that the landlord is carrying over an AGA from a prior year.
You mean banking?
Banking, yes, banking.
So that would be the same thing. It would be a cap at 10% like it already is. So just like when you bank now, it would be a 10% cap for your increase for the year that's inclusive of your banked amounts.
And I'm just trying to figure out if does the 5% and the 10% max, do we get any strange outcomes there?
Now, we already have the 10%. It's in the CSFRA, a yearly increase with all extra, even banked, can never ever be higher than 10%. So I think, yeah, in some years when there is a capital improvement increase approved, you can maybe not use both. You cannot use and the CI and the AGA and a banked increase. So you have to kind of be strategic about that.
Or similarly, just like now, if let's say you hadn't given an increase in multiple years and you could technically raise it based on the banking amount capped at 10%, you could have a situation where you had banked increases plus the AGA that is greater than 10%. You can't give all of that increase. You would just have to wait for the next year for the rest of that banked amount to be applicable, right? So it'd be similar to that.
Right.
Yeah.
All right, thank you.
Does staff feel they could adequately handle that? Is that?
Oh yeah, we already do that with, we provide templates and guidance already about how to bank and use the banking appropriately. We have templates that do the math for people already and help and assist in all of that kind of stuff. So something that we can incorporate in and into the petition process as well. So we can definitely work within the confines of the structure.
All right. Vice Chair Almond, did you still want to do the straw poll for the 5%?
Yeah, I mean, I'm hoping that we can get agreement on that.
All right. So, Andrea, do you mind calling the straw vote?
So we'll start again with committee member Pardo Dezella.
I'm going to sit this one out.
Committee member Haynes Livesay.
I'm going to pass on this one too. I'm trying to figure out the impact on the numbers.
Committee member Grunwald.
Again, I think just for simplicity, I prefer having one number that we communicate, 10%. So I guess I'm a nay.
Vice Chair Almond.
So I agree with Vice Chair Oh, sorry, Vice Chair.
I would be for capping it at 5%. But
And
maybe,
Chair- oh, sorry.
well, I was just going to say, would it help people to vote on this if we saw the numbers in an example? And I guess we couldn't do that today.
Yeah, I just want to say there is some indifference and there are some preferences. So we, in our next regulations, we can bring something back, hopefully that will accommodate all the wishes of the Rental Housing Committee.
And staff would like to note that when you're looking at these numbers, all of these different scenarios are under 5% for an average, what the average rent is in the city right now, including the last one with the highest expenditures. So all of these models would still fit within that 5% cap.
That's good.
But as Anki said, when we bring back regulations, you can still consider, you know, the 10% inclusive of the AGA or the 5% not inclusive of the AGA. And we can also bring back some model math with what rent increases could potentially look like in a situation like that.
I appreciate that. I know it's more work for you guys, but I would appreciate it.
All right. Does staff need any other discussions from us, and what are our next steps?
Next steps are bringing back regulations to the committee for final approval. And you had requested the joint petition process with the regulations as well be brought back at the same time. So that would be the next step.
Is everyone good with that step? Committee Member Grunwald.
I just had a comment. I just wanted to thank staff for, I know we've been somewhat slow in our deliberation on this and had several study sessions, but I think we're approaching alignment and getting to something that seems like it's aligned with other jurisdictions and everyone on the committee is supportive of. So yeah, just again, thank you staff for your due diligence and bearing with us on this long process. Appreciate it.
Vice Chair Allman.
I'd like to second what Matt said. It was an incredible amount of work with all the attachments and sampling and everything else. I just have a question. Have we decided which things we're going to allow to be included under capital improvements? I mean, I saw all the other jurisdictions and all the possibilities, but I'm hoping that we can narrow down a very limited scope.
You have the RHC approved the authorized expenses at the last meeting to consider for the regulations, and they're based on the a review of different jurisdictions and fit within the frame of the regulations and the law. At what staff proposes for the regulation review is we will make sure that there's not two amortization schedules in there. It's only the one that you'll be providing regulations for, so it's less confusing as well.
That'd be great. I think I got very tired at the end of our last meeting, so I forgot whether we had decided or not. Sorry about that. Thanks again.
Okay, I see no other hands up. So in our next available meeting, we will probably get our regulations. Everyone, speak now or forever hold your peace. I want happy staff, so I don't want them to show up with regulations and then we have to send them back because there's a change. So are we good? I want to see nodded heads. Nodding heads, nodding heads. Awesome. Thank you so much, staff. Let's put up work in it and let's get those regulations.
Thank you for the guidance, everyone. It's greatly appreciated.
I have one question for Karen. Do we need to finish the straw poll, or is it fine with the decisions that we have so far? I think we just did not.
I think it's fine. I think we have the direction that we need to come back with regulations.
Thank you.
Awesome. All right, so we are at 10:04. This is usually the time when people say we want to stop. So do we, do people, do we want to delay the next two items till the next meeting? I can't believe I am suggesting that. If we want to plow through, I am totally down, but now would be the time to make that motion.
Yeah, I mean, those two items are easily being carried over to the next meeting, and we definitely want to share some updates under item number 9. So go ahead, make your decision.
The floor is open for a motion.
I'll make a motion to delay this item until the next meeting.
This item and the next one, correct? 8.2 and 8.3?
8.2 and 8.3, yeah.
All right, do we have a second?
I'll second. Oh, great.
All right, we have a motion by Committee Member Grunwald, seconded by Committee Member Parra-Dizella to postpone item 8.2 and 8.3 to the next meeting. Can we do a roll call vote, Ms. Andrea?
Okay, let's start with Committee Member Parra-Dizella.
Aye.
Committee Member Haynes-Livesey.
Aye.
Committee Member Grunwald.
Aye.
Vice Chair Almond.
Aye.
Chair Ramos.
Once again, boo, but aye.
Motion passes unanimously, 5 votes to 0.
All right, so now we have skipped 8.2, 8.3, and we are now at 9, council, staff, and committee reports.
We will make this brief as possible. The first item under item 9 is our monthly status report, and we will be going over this quickly. We have about 500 public inquiries that have been made through the Mountain View Rental Housing Helpline. Staff does want to note that next month this number will look different as we are incorporating our own staff's support out in the public into these numbers. We have 15 workshops for the year with a total of 146 attendees. We've held 26 office hours for a total of 21 attendees. And in case you're wondering why those numbers don't match, it's because we are providing virtual office hours just like we would in person. So we are open and available online through Zoom, and people can register moment of on any Friday from 1 to 3, and we're there for them. We have sent out 15 email updates to 550 subscribers with 10 Mountain View voice ads. There's one that's currently running for the entire month about webinars. And we've done 3 mailings. This was as of January. We've actually done more than that, and we'll have quite a few more in March. We've done 72 mediations and conciliations through the mediation program. 62 of those are resolved, and we have 6 that are left pending. We've had 345 termination notices be filed, and a lot of those, as they always are related to failure to pay rent notices. And staff does want to reiterate that under the state law's eviction, the statewide eviction moratorium, so the state law requires that landlords provide a 15-day notice to pay rent or quit to tenants right now for the tenant to be able to respond and provide their financial hardship declaration back to the landlord. That was not the case. There was at the beginning of the year here. So what you see with Q4 and the start of Q1 is an increase because that requirement by the state came in at the end of Q1 of 2021. We've had 1 household that has received assistance for 2021 in January. We've had 0 properties go into redevelopment and 0 units are affected. We have had 20 petitions, 7 of which are decided, 1 of which is settled, and then we have the 1 in the appeal process and some that are outstanding. Currently in the market, we have Some different vacancy rates for newly built units. The vacancy rate's at 31.4%. It's at 13% for all units, 10.5% for fully covered units, and 8.6% for partially covered units. We are seeing some price rebounding in the market for average market rent across all units. They ticked up a little bit in the past month. And there has been 2 units that sold during this fiscal year. And right now we have 2 properties that sold for a total of 120 units. And we have 5 properties that are on the market for a total of 113 units. Most of those are smaller properties. And then the CPI is the same as it was in December. We'll find out those numbers shortly for the March update. And that is the status report for the month. Are there any questions?
A quick question. The number of mediations and conciliations, what is the time period for that?
So this is the whole fiscal year.
Oh, okay. I was like, that's a lot since January.
No. That would be a lot. No, this is the entire fiscal year.
Okay, so since July?
Yep.
And have we gotten any updates after we got the notices from landlords with the failure to pay rent or quit? Have we gotten any like confirmations that tenant has moved out?
We have not. That is built into the portal. So, and obviously it's required under the regulations now. You all put those regulations into effect this summer, but we have not received any notification that someone has vacated the unit or that they've been forced to vacate the unit.
All right. Oh, I have a hand up from committee member Grunwald.
Thanks. Just a quick question. Are we sourcing, how much of this data are we sourcing yet from the rental registry, or is that still, or when do we think we'd be able to, particularly like average rents and things of that nature?
So right now the information is from CoStar, and the average market rent obviously is not the average rent in the city. It's not what's actually being paid. It's what you would experience if you were going out to find an apartment or a home or a home covered under the law. Andrea does have the numbers on the rent registry and the fee, if you would like to share that, Andrea.
Yeah, I can share that now. And also, I just wanted to mention that all of the numbers about submitted notices, that comes from the registry. But as far as the rent registration goes, so far we have had 180 properties that have completed their registration. So that's accounting for about 3,700 units in the city. And this is about 25% of the properties that have registered, and it is about 26% of the total units in Mountain View that have completed their registration. And us as staff has also reached out to over 150 landlords directly who had partially completed their registration but had not finished submitting it. And we did that on February 12th. And within 1 week, we had an increase of 66 properties that were registered. So we're planning to continue reaching out to landlords who have not completed their registration so we can assist them one-on-one to help them finish filling that out. So there continue to be, of course, those properties that have not finished registering, and we do have quite a few of our larger properties that have well over 100 units on that list, and we are working and in communication with them pretty constantly, helping them finish up and answering any questions and troubleshooting any problems that they might be running into. So we're working and we're hoping, and they're feeling pretty confident about being done by March 1st. So fingers crossed there. And we are also planning some targeted outreach to our smaller landlord community to make sure we get the information out to them, and then make sure that they're not having any trouble online registering their property. Yeah, and I think we'll go over some of our outreach stuff in the coming up slides.
Okay, great.
Any questions about what's going on there?
Not, we don't have to cover right now, but I guess just quickly, March 1st is our deadline where you're still, like, if you go past March 1st, you're not technically in compliance. Is that the case?
Correct.
Okay.
We are still
so,
planning on providing webinars and outreach and support after that date, of course, but that is the date that was decided by the committee.
Got it. Yeah, if we could have maybe a deep dive. Well, sorry, I'll request that later. But thank you.
You can request it now if you want. I can write it down and make sure to have information for you for the next meeting.
Oh, I just thought we might want to have a deep dive, like, agenda item on that. So I think I'd have to go through the chair or make another recommendation. But I won't slow this down any further with that. Thank you, Andrea.
Thank you. Okay, so moving on, we'll go over quickly the landlord-tenant programs in Mountain View. So we're going to start with the eviction moratorium. So as promised to you last meeting, we're going to give you an update. And right after our meeting last month, the eviction moratorium was actually extended. So still, this suspends evictions for non-payment of rent for all residential tenants financially impacted by COVID-19. So that's tenants of CSFRA covered and non-CSFRA covered rental units. And so SB 91 was passed, and that extends the Tenant, Homeowner, and Small Landlord Relief Act that was known as SB 3088. And it effectively just pushes that end date out until June 30th of 2021. So just quickly, as Patricia mentioned, all the same things are still in effect. So landlords would still have to submit to the city and serve on their tenant that 15-day non-payment of rent termination notice, and that has that hardship declaration attached. The tenant would just have to fill that out and return it. The same rent repayment guidelines are still in place, so that 25% of rent from September 20th, but now it's until June 30th, 2021, have to be paid by June 30th, 2021. And the landlords can begin recovering that COVID-related rental debt by August 1st, 2021. And we are giving a lot of workshops on this, which we'll cover in the next couple slides. And again, committee members are more than welcome to join any of those. Just let us know ahead of time because we do not want to have a quorum of you all there. But we do update our website at mountainview.gov/eviction relief. So quickly to just go over some of our outreach that we have done and that we're planning. We have mailed out a postcard to all residents in Mountain View. So every residential address got a postcard, as well as our CSFRA property owners, which of course some of them live outside of Mountain View. We have updated our website and all of our videos, and those are also in Spanish and Chinese. We continue to hold our tenant, landlord, and our bilingual webinars. We've created a nice packet that we are distributing to the school districts, the neighborhood groups, and different community organizations. So that would include the fact sheet that you see there and information on rent relief. And we also are planning in the next week or so some targeted mailings, like a landlord newsletter and a small landlord postcard to go to small landlords. And that would have really key information like our property registration, the rent relief information for both landlords and tenants, and a lot of information on the rent reduction, voluntary rent reduction program policy that you passed. Just by looking at the registrants who have put that information online, it seems like that information may not have gotten out to as many people as are using rent reduction at this moment. So just more education and more support. And so here you can see our planned upcoming eviction moratorium webinars. So we have a couple this week. So we have a landlord tomorrow at 3. On Wednesday, we have one that is going to be bilingual, tenant focused at 6:30. And again, March 2nd and March 3rd for tenants and landlords respectively there. And I'm going to let Patricia talk a little bit more in depth about our rent relief program.
So the City of Mountain View has its own COVID-related rent relief program, and also the Community Services Agency of Mountain View and Los Altos has multiple different types of rent relief programs that provide rental assistance paid directly to landlords. Under SB 91, there are 2 additional chunks of funds that will be distributed to one to tenants and one mostly to landlords. That the monies to landlords are very specific. They have requirements for tenants as well as requirements for property owners, and the state will be distributing all of those funds. So what we're going to do to assist with getting information out about that, especially to smaller landlords that might really need the assistance but would have a harder time applying through the state website, is that we're going to host workshops to help people sign up for that that assistance. So again, the state is going to be distributing those funds through a portal. And then the county will be distributing the funds from the state for tenants. They will have a portal as well. And so every tenant who needs assistance in Santa Clara County that qualifies will go through a portal similar to the information that you see here through the homelessness prevention system. And that will be most likely assisted with by Sacred Heart, who also did this work at the beginning of the moratorium. So Mountain View will actually have like 3 different kind of ways for people to receive assistance for rent relief. And we're going to be helping get the word out about it as much as possible. So once these programs are up and running, we will have links on our website. Like I said, we will be doing specific outreach to landlords for that state money and specific outreach to tenants, getting them the information that they need to then go and access the funds through the other places. And also, there is still money available through the Mountain View Rent Relief Program that tenants can apply for directly at CSA. There also in SB 91 is mortgage relief available, and there are qualifiers here for that. We hosted our first HUD certified mortgage counseling workshop last week, and we're going to continue to hold those for anyone in the community who wants to learn more about how that works. And we have someone from Project Sentinel that joins us and provides the presentation that does the mortgage counseling for that organization.
Ms. Patricia, what kind of attendance did you get on that?
We had, I think, 5 or 6 people come through. Yeah,
I think it was about 5.
So we're hoping with our targeted outreach to small landlords that we'll have a bump up in that, since it is pretty pertinent, important information. There's also still the utility relief program that tenants can apply for funds with through the City of Mountain View, and it will help provide funding for a one-time payment to assist with utility payments. And then we have this long list of our own rent stabilization webinars. So on the 20th, this is not including the eviction moratorium ones that Andrea already reviewed. On top of those, we have one on February 25th for landlord property registration. We also are now starting to do some virtual coffee catch-ups with small landlords at 10 o'clock in the morning on Tuesdays, March 9th and March 23rd. And we're going to have a registration and rent relief focus to these. So if people need help with their registration with one-on-one support, or they have questions about the rent relief that's coming available, we really want to get that information out to them. We have a landlord registration workshop on March 11th, and then we have our monthly webinar. This one's about reasonable accommodations and ADA compliance, and we will have a guest speaker for that. And then on March 23rd, this is tentative right now, but we're hoping to also have the HUD mortgage counseling webinar again on March 23rd. And then we also have our virtual office hours, as I've mentioned earlier. Those are every Friday from 1 to 3, and we're going to be doing workshops in that specific to helping small landlords apply for that state rent relief application. So that is the bulk of our webinars that we're doing, quite a few this month. We're really trying to make sure that people feel that we are here and available even though we're remote. and then just some basic information to end the evening on. Are there any questions about the webinars that we're doing? Or any of the other outreach?
I have a hand up from committee member Grunwald.
Go
ahead. Go ahead.
Oh, I'm sorry.
Oh, no, go ahead. Go ahead.
When we're done, Andrea, could you put up your workshops list? And I just wanted to take a screenshot before we're done.
Although, could you possibly send us the flyers for these workshops? That would make it easier for us to share it with our networks.
Yes, staff can get a flyer together for the month. I'm working on that now.
Great.
We just added a whole bunch of these in here to be targeted for the rent relief. So
great. I don't know how you
guess I was just going to ask for the ones that are, like the HUD mortgage counseling. I mean, that seems not necessarily limited to Mountain View. Do we, are there broader groups that we could, that you could offer it to? I don't know if that makes sense actually, but like some of them seem interesting. And if you're only getting, 5 or 6 landlords for some of them, maybe advertise more widely.
We will be advertising more specifically through the Project Sentinel channels as well. So that should help. And through some of the community organizations, we're also going to be starting to target our property owners through the portal with this information, which we haven't been able to do before.
Awesome. Cool.
I've noticed that you're including like a postcard in the Voice that's publicizing it, and that's very smart. I like that.
Thank you.
You're welcome.
All right. Any other comments? Questions? Concerns?
I did have a brief summary update about where we sort of are with our billing, if you wanted to allow me to quickly go over that.
That would be wonderful.
Okay. So to date, we've collected about 81% of our invoice fees. So that, yeah, it's not bad. So that's about 574 properties, and it's about $1,018,000 so far. And that's about on target where we usually are for end of February every year, about 81%. And so far we have sent out mailings for one set of delinquent and one round of delinquent invoices. So that included people who haven't paid, but then we also sent out invoices with address corrections, of course, in February 1st. So we got, of course, more funds with the delinquent notice and the correct addresses. So that brings us to 81, which is very good. So we still have about 123 properties who have not yet paid, which accounts for about $247,000. And I am currently working on creating a list of those addresses so I can do some personal outreach to them to make sure we have the right billing information for them and their their address and their contact information, and that the invoices are getting to the right people. So that's just an update there.
And the personal outreach, as Andrea would like to refer to it, were very effective last year. So thank you again, Andrea.
No problem.
Is this an issue with repeat offenders, or is it different people each time?
We definitely have some repeat offenders that are on our list, and we do this outreach every year, and we make sure to send them past invoices as well. It's not just the current year's invoice, so they are aware of their outstanding bill. And hopefully with the registration, if they register, we can make sure we're sending it to the right person and the right mailing address, because we do have outdated information right now. And we found somebody today that just had the wrong address for all 3 years. So, so I don't know how much of that is going on. So we'll see. And, we're definitely trying to be on top of that.
That's great. Get that money. All right. Any other questions from the committee? Is there anything else from staff? All right. With that, back to the script. All right. The meeting is adjourned at 10:30 p.m. The next Rental Housing Committee is scheduled to be held on Monday, March 22nd, 2021 at 7 p.m. Have a good night, everyone. Please stay safe.